My name is Lila Bednar.
I'm sorry, I didn't hear that very well.
Sorry, my name is Lila Bednar.
Great.
May our witnesses introduce themselves at this time, Your Honor?
You bet.
My name is Caitlin Duffy.
Great.
My name is Lindsay Harriman.
My name is Abigail Lowe.
All right, that should do it then. And now if I can have our three scoring panelists introduce themselves.
Your Honor, it's Anthony Pereira from Metro Volunteer Lawyers.
And the last name, counsel, I'm sorry?
Pereira.
Pereira.
P-E-R-E-R-A.
All right, thank you.
Good morning, Your Honor. Morgan Patterson from Woody Law Firm.
Thank you.
Sorry, Lee Newman from Arapahoe County Justice Center.
Thank you. But I'll first ask, do any of the scoring panelists, Mr. Pereira, Ms. Patterson, or Ms. Newman, do any of you recognize any of the participants, that is the young folks from the People's Team and from the Defense Team? Do any of you recognize any of those
No.
participants?
No.
All right, thank you. And I've got some brief questions to go over. Make sure we're all on the same sheet of music here. I should let the teams know that the Colorado Bar Association may be, I know this is being videotaped, they may be utilizing some of that videotape and photographs later on. I don't know who's in the gallery right now, but I'll simply ask if there's anybody who's watching, who's in the gallery, who is not associated with these two teams, they must leave this chat process right now. They're not permitted to be present. And I've asked the scoring panelists if they recognize any of the students. They've all indicated they do not. Is there any reason why the scoring panelists could not be fair and impartial to both sides in this case?
I don't have any problems with it.
All right, Mr. Pereira
No, Your Honor.
and Ms. Patterson, pardon me.
No, Your Honor.
All right. I should remind the teams that any disputes arising out of this competition must be reported in accordance with competition rules. There are time requirements and limitations that will be imposed upon you. And I should ask you, you've already introduced each member of the team, so we know all those names. I'm going to next swear in people, but before I do the swearing in process, I'm going to give Ms. Rogers a chance to do that conflict check to see if there are any other courtrooms that need assistance. So Ms. Rogers, I'll wait to hear from you before I swear in witnesses.
So, Your Honor, we did receive confirmation that there are no conflicts in the other courtrooms. I am going to just remind all participants that unless you are a witness or an attorney who will be doing direct or cross-examination, if you could please turn off your videos and mute yourself so that we can save bandwidth. Thank you.
Right, and Ms. Rogers points out that my next area, which is that when we do this process, the only people on the screens will be myself and the lawyer asking, the examining lawyer that is doing the direct examination, the lawyer doing cross-examination, and the witness. So it'll be the four of us on screen. Then when we change roles, we'll admit those folks. But right now, that's how that will be conducted. I'm also going to tell you that when objections are made, if they are made during the course of the trial, when I conduct trials, I usually don't allow a lot of speaking objections, but the rules are a little more flexible here. So if there is an objection made, I would probably allow a brief response and maybe a brief reply to that to let you kind of explain your positions on the record. If it's an area that I don't believe we need that, I'll simply rule, but I think I'll be a little more flexible here during the course of the trial and allow responses and replies to any objections that might be made. So with that in mind, I'm going to have them swear in people first. And so what I'm going to do first is swear in first the team members. And by that, I mean the lawyers. I'll swear in witnesses next. If there are any gallery members that are watching, I'll swear them in. And then lastly, I'll swear in our scoring panelists. So with that framework in mind, I'm going to ask the lawyers for both sides to raise their right hands. And I'll ask you the following question. Team members, do you promise that the presentation you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition? So answer by saying, I do.
I do.
I do.
Great. Now we'll move to the witnesses. If your witnesses would raise your right hands for me. Do you promise that the testimony you're about to give will faithfully and truthfully conform to your witness statements, that you will not add material facts or opinions which are not contained in the case problem, and that you will follow the rules and procedures of the mock trial competition? So answer by saying, I will.
I will.
I will.
Great. If there are any gallery members that are watching right now, I'll simply have you indicate the following. If you would raise your right hands for me, do you promise to represent yourselves as positive role models and to behave in a manner that exemplifies ethical sportsmanship around? So that's by saying, I do. All right. And then lastly, I'll move to the scoring panelists. And if I can have the three of you please raise your right hand for me. Do you promise to adjudicate the mock trial competition as fairly and objectively as possible in accordance with the facts, procedures, and rules of the mock trial competition? So answer by saying, I do.
I do.
Great, thank you. I should also remind the teams that recesses are not to be taken unless there is an emergency. We'll proceed in the following fashion with the presentation of evidence from the prosecution, cross-examination, and then after the people have rested their case, then the defense will be allowed to present evidence if they deem appropriate. All right. Are the parties then ready to proceed to trial this morning? People.
Yes, Your Honor.
Defense. Defense.
Yes,
My
Your Honor.
apologies. Yes, Your Honor.
Thank you. Then do the people desire to make an opening statement at this point?
Yes, Your Honor. Can I first specify that we put our roster in the chat so that the judges may be able to download that? And is there any way we could do an entry of appearances where the witnesses introduce themselves as their character? That's my bad. I set the wrong precedent at the beginning.
And when you say entry of appearance, simply acknowledging who the lawyers are that are examining them?
Yes,
would be
and then the witnesses introduce their character names too.
And then your chat thing, that presumes that you know how that I can figure out how to access chat. I think I'm going to try that right now. All right, I do see the trial roster, the prosecution's trial roster in my chat room. All right, so I would hope that other people would then have access to that. You know, I see it, but I can't pull it up, but that's okay. I wrote the names down.
Okay.
All right, so I believe the people have indicated that they want to proceed to opening statement.
Yes, Your Honor.
You may do so.
All right, before I begin, can everyone see me okay and hear me all right?
Yes.
Perfect. I would get back at Coach Brackman if it was the last thing I do. That's what the defendant promised her mother she would do to the victim, Mackenzie Brackman. You see, Mackenzie Brackman was a beloved high school mock trial coach. He worked as a local attorney, but spent most of his free time teaching high school students the rule of law. While most of his students adored him and appreciated his time, there was one student in particular that gave Coach Brackman a hard time. Avery Becker, the defendant. Because the defendant rarely did the work they were supposed to do, they argued with Coach Brackman. She was rash, emotional, and frankly, unstable. At practice one day, the coach was attempting to give the defendant constructive feedback. But of course, the defendant wasn't having it. They stormed out of practice, angry, and unhinged. She saw Coach Brackman's car and vandalized it by writing all over it with permanent marker. Now when Coach Brackman saw this, he of course kicked the defendant off the team, causing the defendant to be even angrier. That's when the defendant told her mother she would get back at Coach Brackman. It was the last thing she did. So that night she planned to get back at Coach Brackman. The next day she skipped school and she planned to break in and vandalize Coach Brackman's home. And on top of that, she even sent out text messages saying that she wanted to break into Coach Brackman's home. However, there was one issue. When the defendant arrived to the house, the victim was home. A struggle ensued, and the defendant ended up killing the victim rather than getting caught. Because like she said, she would get back at Coach Brackman if it was the last thing she did. Today you'll hear from 3 prosecution witnesses. You'll first hear from Detective Markowitz, who was the lead detective on this case. And she will tell you how she was able to place the defendant at the scene of the crime at the time of the murder. Next, you'll hear from Investigator Kuzak, who assisted with the investigation and reconstructed the crime scene. And I anticipate that Investigator Kuzak will tell you that this was a burglary gone bad, and a burglary turned to murder. And finally, you'll hear from Alex Cifuentes, who was a friend of the defendant, and also the person the defendant shared her plans with about vandalizing the victim's home. Pay attention to their testimony and keep in mind 3 things. 1, who had the motive to kill Mackenzie Brackman? 2, who had the means to carry out this murder? And 3, who had the opportunity to commit this crime? And by the end of the trial, we'll have proven to you that Avery Becker is the only person who meets these 3 things. As a prosecution, we carry the burden in this case. And that burden is to prove to you each and every element of the crimes charged, beyond a reasonable doubt. And we welcome that burden. At the end of the trial, after you've heard all the evidence, my co-counsel, Merce Brockler, will come before you and will ask that you find the defendant guilty. Guilty of first-degree murder and second-degree burglary. Because the defendant was rash, emotional, and violent. Because like she said, she'd get back at Coach Brackman. It was the last thing she did. Thank you.
Thank you, counsel. Does the defense desire to make an opening statement?
Yes, Your Honor.
You may do so.
What makes a good investigation? Is it following up on all possible leads? Is it analyzing the contents of a cell phone? Or maybe it's checking on all possible alibis. Ladies and gentlemen of the jury, today you'll find that the police did not complete any of these tasks in their investigation. A good investigator investigates. They don't take the path of least resistance at the expense of the case. The evidence will show that the police did exactly that. They took the path of least resistance. And now the defendant, Avery Becker, a girl straight out of high school with a promising future, stands before you today, charged with felony murder and burglary. Her life is on the line today because an incomplete investigation by the police led to a false accusation. Let's begin with the day before the murder happened, March 5th, 2020. That day, Avery Becker and her best friend Taylor Perkins were enjoying a meal at Fry Shack, a restaurant they frequented, when their mock trial teammates stepped through the door. This group included a person named Alex Fuentes, who will be testifying for the prosecution today. Taylor Perkins will testify to the interaction she saw between Alex and Avery that evening. The three exchanged some words and then Avery left for the bathroom, upset. Upon returning, Avery left the restaurant with Taylor. The next morning, Avery discovered that her phone had gone missing, likely being left at the fry shack the evening before. So that day, March 6, 2020, Avery and Taylor spent the day retracing their steps, searching for the lost phone. Later that day, they went to the fry shack one last time in hopes of finding the lost phone, only to later discover that their mock trial coach, Mackenzie Brackman, had been murdered. Avery is in this courtroom today because the police took the path of least resistance. But today, you'll hear about someone who was never fully investigated by the police, Blair Rowlands. Private investigator Blake Van Owen will testify to her investigation of Blair Rowlands and how she thinks Blair was tied to this case. Blake Van Owen reviewed the police reports, exhibits, and crime scene reconstruction done for this case. She will walk through what she, in her expert opinion, believe happened to Mackenzie Brackman on March 6, 2020. Today, you'll hear from prosecution witness Detective Jordan Markowitz, who will testify that despite her special training with cell phones, she took the path of least resistance and accepted screenshots of text messages as evidence from Alex Cifuentes instead of analyzing the contents of Alex's phone. Detective Markowitz will tell you that talking to Cifuentes was the biggest break in the case. The only physical evidence Alex gave Detective Markowitz were those emailed screenshots. You'll hear from prosecution witness Kyle Kuzak, who will testify that even though the investigation seemed like a straightforward home invasion crime, she wasn't able to recreate all event segments or place all the evidence. The evidence will show you a picture of an incomplete investigation, one where they didn't follow up on all possible leads, where they didn't analyze the contents of a cell phone, one where they weren't able to place all the evidence. An investigation that followed the path of least resistance. Members of the jury, the prosecution wants you to believe that on March 6, 2020, Avery Becker murdered her mock trial coach, Mackenzie Brackman, who was also a local defense attorney. The defense will present evidence that will show reasonable doubt towards Avery's alleged crimes. The burden of proof beyond a reasonable doubt lies on the prosecution's shoulders. Beyond a reasonable doubt is like a line of dominoes. Once one falls, they all tumble down. A doubt is that first domino. One doubt can make the whole case fall. That means that if you, the jury, have even the slightest of doubts about the evidence or testimony presented in today's case, we will ask you to find Avery Becker not guilty. After hearing all the evidence and testimony, you'll find that there is reasonable doubt. Mackenzie Brackman's death is a tragedy. This tragedy shouldn't cost Avery Becker's life too.
Thank you, counsel. And if we can get your name for our records.
My name is Sasha Latak.
Thank you. That concludes opening statements from both sides. The people then may call their first witness.
The people call Detective Markowitz to the stand.
And this is Ms. Braukler.
Yes.
All right.
All right. Good morning, Detective.
Good morning.
Please introduce yourself to the jury by telling us your name and spell your last name for the court reporter.
My name is Jordan Markowitz, Markowitz.
Before we talk about your investigation and your findings, let's get to know you a little bit better. This may be a super obvious question, Detective, but what do you do for a living?
I'm a police officer with the Denver Police Department.
How long have you been with DPD?
13 years.
What is your current assignment?
I'm a detective with the homicide unit.
Tell us what your duties are as a detective.
Once a crime has occurred and I get assigned a case, I will respond to the crime scene, oversee the collection of evidence, interview any witnesses, and then turn over all of my findings to a crime scene reconstruction expert.
Did you do that in this case?
Yes, I did.
Let's talk about your investigation. Tell us how it started.
On March 6th, 2020, a passing motorist called 911 to report seeing a possibly passed out person on the front porch of a residence.
What was the address of that home?
444 South Flower Street in the city and county of Denver, Colorado.
Who responded to that 911 call?
Paramedics initially responded and determined the person was deceased, and that's when police were called on scene.
Once police were called, what happened?
Officers arrived, secured the scene, and then called me to come and investigate. I came and arrived shortly thereafter.
What time did you arrive at the residence on South Flower Street?
2:20 p.m.
Describe what you first saw when you got to the house.
I saw a deceased adult male lying in a pool of blood.
Did you document the scene?
Yes, I took photographs.
Detective, are you familiar with what's been marked as Exhibits 2 and 5?
Yes, I am.
What are Exhibits 2 and 5?
Exhibit 2 is a photo of the victim inside the home, and Exhibit 5 is a photo of a knife found on scene.
How do you know?
I was there and personally observed these scenes.
Are Exhibits 2 and 5 fair and accurate representations of the victim's body and the knife as you last found them?
Yes, they are.
Move to admit Exhibits 2 and 5 into evidence.
Defense?
Your Honor, to my understanding, this witness has not yet been tendered as an expert in crime scene investigation. However, if this is just what the witness observed, for Exhibit 2, I object to Rule 403, misleading the jury. This is a very gruesome picture that will evoke an emotional reaction in the jury, and there's no reason that this exhibit should be entered when this witness can simply describe how she found the victim's body.
All right, so you're objecting to Exhibit 2, your position on the other exhibit?
I have no issue with the other exhibit, Your Honor.
All right, thank you. Ms. Brockler, brief response?
Yes. I'd first like to address that, yes, Detective Markowitz has not been entered as an expert yet, but these are just her observations and she's allowed to attest to that so far as a lay witness. And also, Exhibit 2 is not unfairly prejudicial. These are only 2 photos, and Exhibit 2 is only 1 photo out of many in this case that are probative of the crime scene, and the jury deserves to see them, especially in a murder trial.
Thank you. What the court will do is admit both exhibits. The exhibit to which the objection was raised, the court notes first, there doesn't need to be an expert background required before that is taken into, pardon me, that's admitted. The witness, it's simply her testimony about what she observed. And obviously the people, when they introduce evidence, it's designed to be prejudicial against the defense. The question is it unreasonably prejudicial? In this case, the court will overrule the objection and will admit exhibits. Was it 1 and 2 that you offered, Ms. Brockler?
2 and 5, Your Honor.
2 and 5 are admitted. You may
Permission
continue.
to publish to the jury by having my co-counsel share their screen.
Granted.
Detective, I'm now going to show you Exhibit 2. Can you describe for us what we're seeing in this photo?
Absolutely. This is the victim from inside the home. As you can see, the victim's shirt appears to be blood-soaked, and there appears to be a puncture wound on the victim's back.
Did you find anything at the scene that you believe could have been used to cause this injury?
Possibly. We found a large steel chef's knife covered in blood near the body.
I'm now showing you what's been admitted as Exhibit 5. Is this the knife you found?
Yes, it is.
Thank you, Mr. Aragon. In addition to there being the victim's body in the doorway, was there anything about the outside of the house that drew your attention?
Yes, I noticed the home was equipped with a Ring doorbell as well as several cameras.
Now that we know what you observed on the outside of the home, let's talk about your observations for the inside of the home. First, did you document your investigation inside the home?
Yes, I had my crime scene investigators take photographs of the inside of the home. However, I later learned that some of the files were corrupted and we weren't able to recover a few photographs.
Well, let's talk about the photos that we do have. Are you familiar with what's been marked as Exhibits 7, 8, 9, and 18?
Yes, I am.
Tell us what each exhibit is.
Exhibit 7 is a picture of a drawer in the kitchen. Exhibit 8 is a picture of a knife block in the kitchen. Exhibit 9 is a picture of the dining area. And Exhibit 18 is a picture of just inside the back sliding glass door.
How do you know?
I was there and personally observed these scenes.
Are these exhibits fair and accurate representations of those items when you saw them?
Yes, they are.
Move to admit Exhibits 7, 8, 9, and 18.
Defense.
No objection, Your Honor.
Those exhibits are admitted.
Detective, which room did you investigate first?
The kitchen.
And what did you find in the kitchen?
I found a partially open kitchen drawer, which I documented in Exhibit 7.
Your Honor, permission to publish Exhibits 7, 8, 9, and 18 to the jury by having my co-counsel share their screen.
Granted.
I'm now showing you Exhibit 7.
Yes, this is a photo of the partially open kitchen drawer. As you can see, it contains several knives.
All right, now Exhibit 8.
Yes, this is a photo of the knife block we found in the kitchen. As you can see, there's an empty slot indicating a missing knife.
I'm now pulling up Exhibit 9.
Yes, this is a picture of the dining area, and as you can see, there's a broken plate on the floor and a knocked over chair.
Aside from those things, was there anything else that stood out to you around the house?
Yes, there were scuff marks just inside the back sliding glass door, which I documented in Exhibit 18.
All right, I'm now showing the jury Exhibit 18. Thank you, Mr. Aragon. Okay, I want to turn back now to the victim. Were you able to determine who he was?
Yes, it was a man by the name of Mackenzie Brackman.
Did the identification of the victim help you further your investigation at all?
Yes, once we knew the victim's name, we were able to recover logins to the victim's ring accounts and access videos captured on March 6th.
Are you familiar with what's been marked as Exhibits 10 and 12?
Yes, I am.
What are Exhibits 10 and 12?
They are videos from the Ring doorbells.
How do you know?
I personally recovered these videos.
Are Exhibits 10 and 12 in the same or similar condition as when you first collected them from the Ring?
Yes, they are.
Move to admit Exhibits 10 and 12.
Defense.
Your Honor, since this witness, although she has not testified to so, she did recover these videos by downloading the contents of the victim's phone, which is something that she received special training and certification to do. I believe that at this point, this does cross the boundary of being something that she would need expert testimony in order to testify as to how she received these videos.
People.
Your Honor, I'm not asking this witness to opine in any way on these videos other than just her simple observations. I'm also not asking her about her process of collecting those videos, just simply the fact that she did collect those videos. So we do not need her to be an expert witness in order to testify to these.
But aren't you asking for the admission of these items?
Yes, Your Honor, because she did use these in her investigation.
Understanding that, I think the argument that's being raised is foundational. That is, that the foundation wasn't appropriate with respect to her being able to acquire these. So on those grounds, the court would sustain the objection.
Okay, Your Honor.
In other words, there needs to be more qualifications for the witness.
Yes, Your Honor, I understand. Detective, let's cut to your experience that you have working with cell phones and CDRs. Do you have any experience working with cell phone records in a criminal investigation?
Yes, I do.
What type of training do you have in the field of cell phone data and analysis?
In addition to the regular training we receive at the police academy, I have specialized training in cell phone data and analysis.
Can you tell us about that specialized training?
Absolutely. I have a cell phone technology and forensics recovery certification from the American Academy of Law Enforcement.
What did you have to do in order to get certified?
I had to complete a 3-day training course and pass the certification test.
What did that training course entail?
We learned about the types of cell phone data, records that can be obtained, how to use software such as the Celebrite system, and how to acquire and interpret both cellular records and cell tower data.
And the training that you received during that course, do you use that training as a homicide detective?
Yes, I use that training constantly as a detective, and I've downloaded the contents of literally hundreds of phones.
Do you also use and analyze cell tower data on a regular basis?
Yes, I do, and I have in over 50 cases.
And did you do that in this case as well?
Yes, I did.
Did you come to any conclusions based on the data you received?
Yes, I did.
And the method you used on coming to your conclusions, are those regularly accepted and relied upon in the scientific community?
Yes, they are.
At this time, Your Honor, we move to tender Detective Markowitz as an expert in the field of historic cell site analysis and interpretation.
Defense.
Pardon me, Your Honor, I don't believe that there has been enough foundation laid for historic cell phone technology.
Is that it?
Yes, Your Honor.
Thank you. The court will overrule that objection and will admit the witness to testify with respect to her qualifications as an expert in the field just articulated. Are you re-offering the exhibits then, Counsel?
Yes, Your Honor. Exhibits 10 and 12.
And for the defense, then your position now on their admissibility.
Your Honor, no objection.
Those items are now admitted.
All right. Permission to publish to the jury by having my co-counsel share their screen.
Granted.
Detective, I'm now going to play Exhibit 10. Can you walk us through what's happening here?
Absolutely. So as you can see, the intruder is looking around and approaching the front door. And as of now, they're trying the doorknob unsuccessfully. And now they'll go around to the side of the house since the gate is unlocked. And in the next video,
that's Exhibit 12.
we notice that the intruder is illegally entering the home through the back door.
All right. Thank you, Mr. Aragon. Detective, in addition to the Ring cameras, was there anything else that you learned from the victim?
Yes, we found a number of email and text messages related to something called mock trial.
Why was this useful?
With a little digging, we were able to find out that Coach Brackman was a coach for Colorado High School's mock trial team. With this information, we reached out to the school and got the contact information for all of the students on the team.
What did you do with that information?
We reached out to several students.
Who was the first student you reached out to?
Alex Cifuentes.
Now, without going into everything that Ms. Cifuentes told you in your interview, because of course that'd be hearsay, tell us what you did next in your investigation based on your interview with Alex Cifuentes.
I got a court order to obtain the cell phone account records for Avery Becker.
Why?
Because Alex Cifuentes told me that Avery Becker had texted Ms. Cifuentes with a plan to break in and trash the victim's home.
Objection, Your Honor. Hearsay.
Response.
I'm going to address this hearsay within hearsay. First of all, we're talking about text messages from the defendant. Therefore, it is a statement by a party opponent. And that second layer of hearsay, getting these text messages from Ms. Cifuentes, those are not being offered for the truth of the matter, but rather the effect on the listener, Detective Markowitz, so that she could move forward in her investigation.
The issue has to do with the fact that Mr. Cifuentes, told things. That's the issue of the hearsay. So if you want to respond to that, I understand the hearsay and hearsay with respect to the text themselves, but it's the issue of what Mr. Fuentes said that led her to do what she did. That's the issue with hearsay. If you want to respond to that.
Yes, Your Honor. As I was trying to articulate, this is going for the effect on the listener, as in this laid an established motive for Avery Becker in Detective Markowitz's case. Therefore, she used this information to move forward in her case.
Any reply to that from the defense?
Your Honor, the witness already testified as to what the interview with Alex Cifuentes caused her to do. So any statement that would have had anything to do with the effect on the listener would have been made before she made that statement. Therefore, this statement, it's unclear what it's being used for, which is why I think that it's being used for the truth of the matter asserted.
It is. The court will sustain the objection.
Detective, why was this interview with Ms. Cifuentes relevant?
It established a motive for Avery Becker to break into the victim's home.
Now, who is Avery Becker?
Avery Becker was a high schooler on the victim's mock trial team.
Through the course of your investigation, did you ever view a photograph of Avery Becker?
Yes, I did.
At this time, Judge, I ask that everyone in the virtual courtroom turn on their cameras so that the witness may make an identification.
Granted.
Detective, do you see Avery Becker in this virtual courtroom?
Yes, I do.
Please identify them by describing what they look like and a piece of clothing that they're wearing.
They have brown hair and they're wearing a gray blazer.
May the record reflect that the witness has identified the defendant subject to cross?
It shall.
Detective, how are Avery Becker's cell phone records important to your investigation?
They corroborated what Alex Cifuentes told me, and it informed me of Avery Becker's location at the time of the murder.
All right, Detective, let's talk about what records you obtained in this case and what you learned from them. What are CDRs?
CDRs are a record of all the calls a phone has placed. They can also inform someone of the location of a cell phone.
How does it show you the location?
In general, a cell phone will connect to the nearest cell tower. This can tell someone the location of the cell phone at that time.
What did you learn from Avery Becker's cell phone records?
I learned Avery Becker's cell phone location at the time of the murder.
And what was that location?
Avery Becker was at the scene of the crime at the time of the murder.
Thank you. No further questions.
Cross-examination.
Yes, Your Honor. Detective Markowitz, let's begin by going over your investigation of the crime scene. You arrived on the scene at 2:20 p.m. on March 6th of 2020, correct?
Correct.
You noted that the residence was in slight disarray,
Yes.
although not enough disarray for you to tell that there was a struggle.
Initially, yes.
You saw the victim's body near the front door.
Yes.
You recognized the victim as Mackenzie Brackman.
Yes, only after I had ID'd him.
You recognized him because you'd been cross-examined by him on several occasions.
Yes.
So you were aware that he did criminal defense work?
Yes, I was.
You realize that as a criminal defense attorney, Mr. Brackman may have been targeted by a disgruntled ex-client?
It was a possibility.
As a detective, you consider it important to follow up on all possible leads, right?
Yes, I do.
Yet you didn't do any further investigation into potential ties between Mr. Brackman's murder and his career as a defense attorney, did you?
No, the reason I didn't investigate former clients is because, as you know, attorney, all client-attorney communications are privileged, and therefore I cannot access those communications.
Was that a no, detective?
No, but it was for a very specific reason.
In fact, the very first student that you called gave you your biggest break in the case.
Yes.
This student was Alex Cifuentes, right?
Correct.
You invited Alex Cifuentes in for an interview because she claimed that she received a text from another student about wanting to trash the victim's house.
Correct.
In this interview, you asked to see Alex Cifuentes' phone.
Correct.
But Alex did not have it on her.
No.
Weren't the text messages on Alex Cifuentes' phone the reason you called her in for an interview in the first place?
Yes, they are.
As a detective, you had never before encountered a teenager that did not bring their phone with them?
That's true, but under the pressure that Alex Cifuentes was under, I can empathize with why Alex Cifuentes didn't bring their phone to the interview.
You've learned how to use forensic software such as the Celebrite system to download information from cell phones, correct?
Yes.
You use this training constantly as a detective, don't you?
Correct.
Did you use the Celebrite system to download the text messages on Alex Cifuentes' phone?
I simply couldn't. I would have if I could. I just couldn't get a warrant for it since Ms. Cifuentes is not a suspect. In addition, what Ms. Cifuentes told me in her interview with me was consistent with what the text messages had shown. So there was almost no reason to doubt that.
Detective, I just want to make it clear, you're testifying today that Alex Cifuentes was not a suspect.
Yes, she was not a main suspect. My only lead in this case was Avery Becker.
We'll keep that in mind as we move throughout the trial. Detective, if Alex allowed you to see her phone, you would have been able to use the Celebrite system, correct?
Correct, but unfortunately, Alex Cifuentes was very nervous and didn't bring their phone to the interview.
Didn't Alex Cifuentes offer to bring the phone in?
Yes, but due to the pressure of having to talk to the police and the surrounding investigation around a murder of someone that they loved so dearly, the nerves must have got to Alex.
Detective, I'll clarify. I'm talking about after this initial interview.
Can you please restate your question? That was a little vague.
After the interview, didn't Alex Cifuentes offer to bring the phone in?
Yes, that's correct.
Yet you didn't have her bring the phone in.
No, because there was no reason to doubt what Alex Cifuentes had given me.
Instead, you asked Alex Cifuentes to send you screenshots of the text conversations with Avery, didn't you?
Correct, but there was no reason to doubt these. And again, I couldn't get a warrant for Alex Cifuentes to give me their phone.
Ms. Cifuentes didn't send you these screenshots immediately after the interview, did she?
No, but that's okay. I can understand the circumstances were very tough. Alex Cifuentes was going through grief.
You never verified the authenticity of those screenshots by looking at Alex Cifuentes' phone yourself.
Once again, I couldn't get a warrant.
Objection, Your Honor. This has been asked and answered. We know that the detective did not look at Alex Cifuentes' phone.
Response.
Your Honor, this question is a little bit different since it's talking about the detective verifying the authenticity of these screenshots, and this is a very important part in the investigation.
Well, you can ask her a question about whether she verified the authenticity. I'll certainly permit that. So go ahead.
You never verified the authenticity of those screenshots by looking at Alex Cifuentes' phone yourself.
No, but again, the surrounding circumstances didn't have any reason for me to doubt Alex Cifuentes' text messages.
In fact, nobody verified the authenticity of those screenshots.
No, because once again, Ms. Cifuentes, what she told me in her interview lined up with exactly what she sent me.
Let's go over some of the information you gathered from your investigation, specifically the call detail records. A service provider does not keep all of the information a cell tower has access to, right?
Correct.
So you did not have access to all of the cell tower records, but rather the call detail records.
Correct.
Call detail records are instances of communication with the cell phone through call or text.
Correct.
So they don't show where a phone is at all times, but rather which tower the phone is connecting to when the phone receives or sends a message.
Objection, Your Honor. Compound question.
Overruled.
I'll repeat the question, Detective. Call detail records don't show where the phone is at all times, but rather which tower the phone is connecting to when it receives or sends a message.
Correct.
They also don't show the content of the messages.
No.
These call detail records that you obtained showed that Taylor Perkins' cell phone was communicating with Avery's.
Correct.
The records indicate that these calls and texts went unanswered.
Correct.
You made a diagram about these call detail records, didn't you?
I did.
Your Honor, permission for my co-counsel to constructively share Exhibit 15 with this witness?
With the witness, she may.
Detective, is this the diagram that you made?
It is.
Is this a complete and accurate copy of that diagram?
It is.
Your Honor, at this time, I move to admit Exhibit 15.
People.
No objection, Your Honor.
Exhibit 15, is it, what, pardon me, I missed the number, but it's admitted.
Your Honor, permission for the jury to now see this exhibit as well.
Because it's been admitted, the publication may now occur.
Detective, you labeled Blair Rowland's residence on this diagram, didn't you?
Correct.
Blair Rowland's residence is within the same area of the specific antenna that Avery Becker's is?
Correct.
Yet, knowing this, you still did not make any efforts to investigate Blair Rowland's.
No, because Avery Becker is the only lead in this case. There is so much evidence against her. Number one, her CDRs place her at the scene of the crime.
Thank you, Detective. That will be sufficient. No further questions, Your Honor.
Redirect.
Yes, Detective, I want to give you an opportunity to talk about that last question there that you were asked on cross. Why didn't you look into Blair Rowland's?
Because Avery Becker is the only reasonable lead in this case. We have to understand that her CDRs place her at the scene of the crime at the time of the murder. There's also the build from the Ring cameras that we can see that's very similar to Avery Becker. Her surrounding circumstances and relationship with Coach Brackman show that she had something against Coach Brackman. And those all lead up to the fact that Avery Becker committed this crime.
Thank you. No further questions.
Cross-examination based on that.
Briefly, Your Honor. Detective, despite how sure you were about Avery Becker, you still thought Blair Rowland's significant enough to label on that diagram, didn't you?
Yes, I labeled him on the diagram, but that has no correlation as Avery Becker has way more evidence against her than Blair Rawlins does.
No further questions, Your Honor.
Thank you. You may step down then. This witness is excused. The people may call their next witness.
Your Honor, the people call Alex Cifuentes to the stand.
All right.
Good afternoon, Ms. Cifuentes.
Good afternoon.
Let's start out with something easy. Tell us your name and spell your last name for the court reporter.
My name is Alex Cifuentes, Sifuentes.
Ms. Cifuentes, tell us how old you are.
I'm 17 years old.
Are you in school?
Yes, I go to Colorado High School. I'm a senior.
What are some things you like to do at school?
I enjoy hanging out with my friends, and I'm also on the mock trial team.
Were you on the high school mock trial team last year?
Yes.
Tell us who your mock trial coach was last year.
Mackenzie Brackman.
And what was Coach Brackman like?
He was a really caring coach who always helped his students. I really enjoyed working with him.
And did you have any friends on the mock trial team last year?
I was pretty good friends with Avery Becker.
And what was that friendship like?
Well, Avery and I really only hung out at mock trial practice and other related events, but we got along well, and we pushed each other to be better students.
You mentioned spending time together at mock trial practice. Did you also have the ability to observe how Avery Becker and Coach Brackman interacted?
Yes.
Did they appear to get along?
Not really. They seemed frustrated with each other.
What gave you that impression?
Well, Avery rarely came prepared for practice, and Coach Brackman was always getting on Avery's back about being more prepared.
Give us an example of a time when Avery was then unprepared.
At the regionals tournament, it was pretty clear that Avery was unprepared for court, but she still managed to win a Best Attorney award. But after the tournament at practice, Coach Brackman was really laying on to Avery because of how unprepared she was.
How did Avery appear to react?
Avery looked so angry. You could just tell she was infuriated because she stormed out of the classroom.
And what happened when she left practice?
I saw her grab a Sharpie permanent marker on her way out of the classroom, and then she went into the parking lot.
How did you know it was a Sharpie permanent marker?
I could just tell by the way it looked. It's very distinct. The Sharpies in that classroom look very different from other markers like dry erase markers.
What happened in the parking lot?
Avery vandalized Coach Brackman's.
Objection, lack of personal knowledge.
Response.
Your Honor, this is not a lack of personal knowledge. The witness was there at these events and is testifying to their observations to them. They were clearly there in the mock trial team.
All right, the court will overrule the objection.
What happened in the parking lot?
Avery vandalized Coach Brackman's car by writing Worst Attorney Award with permanent marker on the car.
Did Coach Brackman know that Avery did that?
Yes, he caught her.
Mr. Fuentes, I want to talk now about what happened after the car vandalism incident. Did Avery Becker ever reach out to you after being kicked off the team?
Yes, she texted me.
And did you save a copy of this text conversation?
I did.
And did you also provide that to Detective Markowitz in this case?
Yes, I emailed her a screenshot.
Are you familiar with what's been marked as Exhibit 14?
Yes, I have a copy in front of me.
What is Exhibit 14?
It is a screenshot of the text conversation between me and Avery.
How do you know?
I recognize what we said to each other, and that's also how Avery's contact is saved in my phone.
Is Exhibit 14 in the same text conversation as you last had with Avery that day?
Yes.
Your Honor, the prosecution moves to admit Exhibit 14 into evidence.
Defense.
Yes, Your Honor, I object per Rule 1002's requirement of an original.
Reply.
Your Honor, this is the original text conversation. They have not been altered in any way. It is the same and similar condition to as when she last had them. They're simply screenshots of these text messages.
The court will overrule the objection and admit the exhibit.
What did Avery Becker text you?
Avery texted me and asked me to talk to Coach Brackman on her behalf and convince him to let her back on the team.
Did you agree to do that for her?
Yes, but I also let her know that I doubted anything would change his mind.
How did Avery respond to that?
Avery texted back, well, if he's still upset about his car, then he's going to be really upset when he sees what I do to his house.
How did you respond?
I asked, what are you going to do to his house?
And what did Avery Becker tell you?
She texted, I'm going to wait till he's at work, then break in and trash it. That'll show him.
At this time, Judge, the people request permission for my co-counsel to publish Exhibit 14 to the jury by sharing their screen.
This is the one that was admitted just recently?
Yes.
You're telling the court, yes. The court will, once it's been admitted, it may be published.
Thank you, Mr. Aragon. And thank you, Your Honor. I have no further questions for this witness at this time.
Cross-examination.
Good morning, Ms. Fuentes.
Good morning.
Let's begin by discussing Avery Becker. You mostly spent time with Avery at mock trial related events, right?
Yes.
Was that a yes?
Yes.
You worked really hard to perfect your skills in mock trial?
Yes, I took my role on the team very seriously.
Avery didn't put as much work into mock trial as you did, right?
Yeah, she was a little unprepared sometimes.
Yet Avery was also very successful in mock trial?
Yes.
It upset you when Avery won the Best Attorney Award and the Best Closing Argument Award?
It was pretty upsetting, yes, but we were also equally skilled, so it was understandable.
You didn't win any awards at this regional tournament, did you?
No.
Avery's success was a slap in the face, as you put it?
It was a slap in the face to the whole team that she won awards without preparing, but like I said earlier, we were equally skilled and it was understandable that she won them.
Avery leaving the team benefited you, right?
Yes, I could have gone a larger role, but Avery was still a year older than me, and so I was understandable that Avery had a larger role.
Let's talk about what happened after Avery was removed from the team. You saw Avery at the Fry Shack the night she was removed from the team?
Correct.
When you saw Avery at the Fry Shack, you had access to her phone, correct?
Yeah, she let me play a game on it, and that was it.
You also testified that Avery supposedly sent you text messages after she was removed from the team?
Yes, she asked me to talk to Coach Brackman.
To clarify, you played these games on Avery's phone on March 5th, the night before Mr. Brackman's death, correct?
Correct.
Let's now discuss your interview with the police. You didn't bring your phone to the interview?
No, my phone was really old and the battery was really bad, so I accidentally just left it charging right before the interview.
You knew the interview was about these texts on your phone, correct?
Yes, but that was my mistake. I just left it charging.
Detective Markowitz asked you to send her screenshots of these text messages?
Yes.
You emailed the screenshots to the detective?
Yes.
You also got rid of the phone containing these alleged text messages?
Yes, well, like I said, the battery was really old, and so I ended up getting a new phone.
You don't know where the phone is now?
Correct, I got a new phone.
In addition, you didn't initially approach the police when you had received these screenshots?
Yeah. Do you mean the text messages?
Yes, excuse me, the text messages.
Your Honor, relevance.
Response, pardon me.
Your Honor, this is relevant per 401A. This is certainly, when we apply the relevance test, this fact makes it more probable that Alex tampered with these screenshots prior to giving them to the detective. And this fact is, of course, in consequence in determining that action.
Thank you. Reply.
Your Honor, this is not relevant that she didn't turn them in before. The witness was simply undergoing grief and sent the screenshot text messages as soon as she could. And that may not have been immediately, but it was as soon as she could have sent those text messages.
Thank you. Understanding that argument, the court will overrule the objection. I do believe there is relevance with respect to this. And I'll let the jury determine how significant that is, but the court will overrule the objection. You may continue, Ms. Bednar.
Ms. Cifuentes, would you like me to repeat the question?
Yes, please.
You didn't initially approach the police when you had received these screenshots?
No, I was in shock, and honestly, I really didn't think that Avery was going to go through with something like this.
The police contacted you regarding these screenshots, or text messages, excuse me, correct?
Yes.
Thank you. No further questions, Your Honor.
Thank you. Redirect.
No redirect, Your Honor.
All right, thank you. This witness may then be excused. The people may call their next witness.
Thank you, Your Honor. The people call Investigator Cusack to the stand.
All right.
Awesome. Good morning, Investigator Cusack.
Good morning.
Please introduce yourself to the jury, starting off by telling your first and last name and spell your last name for the court reporter.
My name is Kyle Cusack. Cusack is spelled K-U-Z-A-K.
Now, before we get into the details of your investigation, let's get to know you a little better. What do you do for a living?
I'm a crime scene reconstruction investigator, or a CSR as we are called.
What is a crime scene reconstruction investigator?
A crime scene reconstruction investigator is called onto a case once all of the evidence has been collected. We then sort through and analyze the evidence to ultimately come to a conclusion based on the facts of the case, our training and expertise, and scientific reasoning.
How does someone become a CSR?
To be recognized as a CSR in Colorado, you must be certified by the Colorado Bureau of Investigation.
And are you yourself certified by the Bureau?
Yes.
How did you obtain your certification?
I had extensive training in the field of crime scene reconstruction as well as investigation.
Where do you work as a CSR?
I work for the Denver Police Department.
How long have you been a CSR?
For the past 19 years.
And how long have you been doing that with DPD?
The last 3.
What type of crimes have you investigated?
I'm usually called on complex crime scenes such as armed robberies, home invasions, homicides, and other property crimes.
And are you the CSR in the murder investigation of Mackenzie Brackman?
Yes.
As a CSR in this case, did you form certain opinions about how this crime was committed?
Yes, I did.
What did you rely upon for these opinions?
I reviewed all the police reports and exhibits. I also visited the crime scene after it was processed. I visited with the crime lab, and I furthermore reviewed the autopsy report.
Now, the training you used to form your opinions, is this the type of training regularly accepted by the scientific community?
Yes, it is.
And have you reliably applied those principles and methods to the facts of this case?
Yes, I did.
Your Honor, at this time, the people move to tender Investigator Cusack as an expert in the field of crime scene reconstruction pursuant to Colorado Rule of Evidence 702.
Defense.
No objection, Your Honor.
That request is granted. She'll be admitted as an expert within that field and be permitted to render opinions within that field. You may continue.
Thank you, Your Honor. Investigator Cusack, before we get into your opinions on this case, let's talk about the opinion on the evidence you relied upon for those opinions. What evidence was significant in your investigation?
I focused on 3 main areas of evidence, first being the ring videos, second being the photographs, and third being the autopsy report.
All right, let's break each one of those down and talk about each one of those. Starting with the ring videos, what did you learn from the ring videos?
From the ring videos, we learned that the suspect approached the Brackman residence on the afternoon hours of March 6, 2020. They first tried the front door, but was unsuccessful, and they ran on the back slide gate to the back sliding glass door.
Were you able to make any determinations about who the suspect was based on the ring videos?
From the videos alone, no. However, they matched the general height and build of the defendant.
In addition to the mask, was anything else hindering their identification?
Yes, the suspect was wearing gloves.
Turning now to the photographs of the scene, talk us through what you learned from them.
Well, one of the first photographs I looked at was a photograph of scuff marks by the back door, which I believe is Exhibit 18.
My co-counsel is showing you what has already been admitted as Exhibit 18. What did that indicate to you?
This indicated to me that a struggle occurred by the back door.
Thank you, Mr. DeRose. In addition to the scuff marks, what other evidence was significant to you in that area of the house?
There was a knocked over chair and a broken plate in the dining area.
Why was that significant?
Well, the dining area is about 5 feet from the back door, so it suggested that the struggle from the back door moved towards the dining area, which was just outside the kitchen.
You mentioned the kitchen. What evidence did you find there?
There was a knife block missing its chef's knife.
Why was that significant?
Well, as there was a chef's knife found by the victim's body and a missing chef's knife in the knife block, this indicated to me that the murder weapon came from the kitchen.
Describe the chef's knife that was found near the body.
It's an all metal knife. Its length is about 12 inches with the blade measuring about 7.5. It's approximately 2 inches wide at its widest point.
In addition to the knife block, what other evidence did you find in the kitchen?
There were blood droplets that began in the dining area and led towards the front door.
Why was that significant?
This was significant because it indicated to me that the victim was stabbed in the dining area, but however, ultimately ended up by the front door.
Earlier, you mentioned an autopsy report. What did you learn from that report that you relied upon in your investigation?
The medical examiner determined that the cause of death was penetrating trauma to the thoracic aorta.
Objection, hearsay.
Response.
Your Honor, this is hearsay, but pursuant to Rule 703, facts or data need not to be admissible for an expert opinion to be admitted. In this case, Investigator Cusack reasonably relied on the autopsy report, informing her expert opinion, thus it's admissible.
Reply.
Your Honor, the autopsy, as Ms. Cusack can testify to her observations at the crime scene and her what she did at the crime scene pursuant to crime scene reconstruction, but how the victim died and exactly how the victim died is outside of her area of expertise.
Thank you. The court will overrule the objection. While certainly she's not a pathologist, she can rely upon the pathologist's report. It's not as if there was a challenge to the pathology report with respect to its admissibility. So the court's going to find that this is something the expert relied upon, and the court will overrule the objection. You may continue, Mr. Aragon.
Earlier, you mentioned autopsy report. What did you learn from that report that you relied upon in your investigation?
Well, the medical examiner determined that the cause of death was penetrating trauma to the thoracic aorta.
What did that report tell you?
Essentially, that the victim was only stabbed once, however, this injury turned to be fatal.
Did the medical examiner determine why this one injury was fatal?
Yes. So when the knife was inserted into the victim, the knife obstructed and slowed any internal bleeding. So once the knife was removed, the victim would have lost a significant amount of blood, leading quickly to death.
Did you have the knife found at the scene tested for DNA and fingerprints?
Yes. However, the only DNA found belonged to that of the victim, which wasn't that surprising.
Why is that not surprising?
Well, as I've mentioned before, the suspect was wearing gloves, inhibiting them from leaving any DNA at the crime scene.
Given all of that, what is your opinion on how this crime occurred?
Well, the physical evidence leads to only one conclusion. That is that the victim was alerted of the intruder via Ring security system and went to go search for a defensive weapon, the chef's knife from the knife block. They then confronted the intruder when they entered through the back door, and a scuffle occurred over the knife. During that struggle, the intruder must have gained possession of the knife and stabbed the victim in the upper back shoulder area. The victim then removed the knife and bled to death.
How did you reach that conclusion?
Well, it's obvious that the knife came from the kitchen. Concerning that there was a missing knife in the knife block, there was an open knife drawer, not to mention there was a knocked over chair, a broken plate, and scuff marks by the back door, which all indicate a struggle.
Why does it matter who introduced the knife in the struggle?
As the intruder was the one who clearly did not introduce the knife, it shows that they did not enter the home with the intention of committing a murder, but more so entered the home with the intention of committing a property crime like a burglary, but was surprised to see the homeowner there.
Thank you. No further questions, Your Honor.
Cross-examination.
Yes, Your Honor. Before I begin, may I request a time check?
Sure. You got it?
Yes, Your Honor. Thank you.
Great. Go ahead.
Let's begin by talking about the scene of the crime. There were a series of small blood droplets that began near the kitchen table and led to the front door.
Yes.
the photos of those blood droplets were corrupted and lost.
Yes.
There were pictures of the blood cast off from the victim pulling out the knife.
Yes, I did review those.
Those too were corrupted and lost.
I wouldn't say they were technically kind of lost. I mean, corruption is more of a technological issue, so it wasn't like we lost evidence. It's just nothing that could be really helped.
So you're testifying that you didn't lose these pieces of evidence?
They were corrupted.
So you're testifying that they weren't lost?
It depends on if you want to say that corruption is lost. I mean, corruption is more of a technological issue.
Let's move on. There are no photos of that evidence for the jury to review today.
Yes, as I stated before, they were corrupted.
No blood splatter or droplets are found in the photos of Brackman's dead body.
Yes.
You would have preferred to have more physical evidence at the scene.
Yes, I mean, that's the case for all crime scenes I really work on.
You couldn't put together exactly what had happened?
Yes.
Yes, you could put together exactly what had happened?
I mean, with the degree of certainty, yes.
You weren't able to recreate all event segments?
Correct.
You were not able to place all the evidence?
Correct, as I stated before, but the conclusion I reached was the most probable of all the scenarios.
Even though, with all of this, the investigation seemed like a straightforward home invasion crime.
Yes, I would say so.
Let's move on and talk about your witness tracking spreadsheet. Do you have a copy of Exhibit 17 in front of you?
Let me pull it up here. Yes.
You recognize Exhibit 17?
Yes.
Exhibit 17 is your witness tracking spreadsheet, your physical evidence tracking spreadsheet, as well as the flow chart you used in your investigation.
Correct.
You regularly, you know what this is because you use this in your first case management step.
Yes.
You regularly use this step in your investigation.
That is correct.
You use this to formulate your expert opinion.
Yes, it helps me get a macro view of all the evidence.
You use this to summarize key points of information from witnesses and suspects.
Correct.
You use this to summarize observations about the evidence.
Yes.
Move to admit Exhibit 17.
Peel.
No objections, Your Honor.
Exhibit 17 is admitted. It also may be published if that's what you're requesting next.
Let the record reflect that I am showing Exhibit 17. Are you able to see this, Ms. Kuzak?
Yes, I am.
So this is the full exhibit, but I will just be referencing your witness tracking spreadsheet. You use the interview report to summarize this information?
Yes.
One of the witnesses listed is Taylor Perkins.
Correct.
Taylor provided statements about where she went with Avery on the day preceding and on the day of the murder.
Yes.
You continually referenced an S3 in your summary of information.
Yes.
That person being an unlocated party.
Correct.
That party being Blair Rowlands.
Yes.
But you only listed 2 suspects on your spreadsheet.
That is correct.
One of them being Alex Cifuentes.
Yes.
No further questions, Your Honor.
Thank you. Redirect.
No redirect, Your Honor.
All right. This witness may then be excused. Do the people have any additional witnesses?
No, Your Honor, the people rest.
People rest. All right. Thank you. The defense may then call their first witness.
Your Honor, the defense calls Avery Becker to the stand.
All right.
Good morning, Ms. Becker. Please state your name and spell your last for the record.
My name is Avery Becker, Becker.
What would you be doing on a normal day in March 2020?
Well, I attended
Relevance. Oh, I'm sorry. I'm objecting to relevance as well as calls for narrative.
Response?
Your Honor, this is laying foundation as to the defendant's activities.
I'm sorry, you said the question was a normal day?
Yes.
What I think I'm going to do is require you to tie and make a little bit of foundation with respect to time. She could certainly testify about what she was doing around that time, but I don't think it's relevant to what she did 6 months prior to that. So let's tie the question in to a normal day at that time, and then I'll permit that. So you may continue.
Your Honor, the question was, what would you be doing on a normal day in March 2020?
Correct. That's fine.
Okay.
I will overrule any objection to that question. I do find it relevant. You may proceed.
Well, as I was saying, I was a student at Colorado High School, so I would most likely be attending school on this day.
What activities were you involved with at your high school?
I was involved in mock trial for all 4 years of high school.
How did you feel about being on the mock trial team?
I liked it for the most part. I loved doing the closings and especially the rebuttals, but my coach and I did not see eye to eye on work ethic, which was frustrating.
Let's discuss your relationship with Mr. Brackman. How did you know Mr. Brackman?
Mr. Brackman was my mock trial coach for all 4 years.
What types of roles did Coach Brackman assign to you?
Well, when I was an attorney, I got the privilege to do the closings and the rebuttals. And I also got the opportunity to play a lot of expert witnesses, which I loved.
Were there any moments where you and your coach disagreed about your skills in mock trial?
Yes, definitely. Like I said, I thought mock trial was more of an art and sort of off script type of club rather than just reading a script. And Mr. Brackman and I had a huge conflict over regionals. He called me out in front of everyone when I said when I just won best attorney. He just started calling me out in front of everyone for not being prepared, saying I didn't deserve it and I only relied on my good looks. So that really did frustrate me, hearing that from my coach.
How did Mr. Brackman's criticisms make you feel?
It made me feel pretty bad and upset and mad. Like, I feel that's normal. I mean, he's my coach.
What, if anything, happened to Mr. Brackman's car?
Well, after he was talking to me about regionals and I just got upset, I took with what I thought was a erasable marker and I wrote on his car. I regret it so bad. That was such a stupid mistake.
How did you feel after this incident?
After this incident, I was able to cool down and collect my thoughts, and I knew I had to go apologize to Mr. Brackman. I went in person, but his secretary declined and said he didn't want to see me. So I just...
Talking about the secretary and what she said, that is hearsay.
That was hearsay. I don't believe I heard anything from the secretary yet, so the court's going to overrule the objection at this point in time because I don't think the secretary said anything, or at least I don't recall her saying anything in particular. So, Ms. Bednar, you may continue with your examination, understanding, of course, that what the secretary said would be hearsay unless it fits an objection. So you may continue.
Ms. Becker, my apologies, you may continue.
No, it's all right.
From your perspective, what was Mr. Brackman's impact on the mock trial team?
Well, even though we did not see eye to eye on work ethic, he did get us to a competitive spot. I mean, last year we were going to go to state, but that was just canceled because of COVID.
How did you feel when you learned of Mr. Brackman's death?
I was devastated. I never got to end on good terms with him. It was just horrifying, even though we didn't have the best relationship, that my mock trial coach of all 4 years, I was never going to talk to again. And I just never got to make amends with him.
On Mr. Brackman's experience, what did he do in addition to coaching your mock trial team?
Mr. Brackman was a criminal defense attorney.
Were there any associations that you knew of between your coach and anyone at your school outside of mock trial?
Yes, Mr. Brackman always tried helping out Colorado high school students.
This is a lack of personal knowledge.
Pardon me, response?
Your Honor, Avery would have knowledge of other students that her coach would have been involved with, and this is her rationally based perception of her coach.
Thank you. Reply.
I actually also object to lack of foundation. Even if she has understanding of hearing it from other people, there has not been proper foundation of how she would hear that or be able to.
What the court's going to do is I will overrule the objection if the question is based upon her own rational observations of the conduct of the victim in this case. So you may continue with that, Ms. Bednar.
I'll repeat my question, Ms. Becker. Were there any associations that you knew of between your coach and anyone out at your school outside of mock trial?
Yes, Mr. Brackman was always trying to help out Colorado high school students. So there's this kid, Blair Rollins, at her school, and basically Mr. Brackman took on Jonathan's Rollins case for murder, I believe, and Mr. Brackman lost it, which ended Jonathan's Rollins' dad in jail.
I'm objecting to hearsay again. We don't know where she heard this from, and decidedly it's hearsay.
Response.
This is not hearsay, an exception to hearsay under 8033, expressing Avery's emotional state at this time and her mental perception from what she could perceive from Jonathan Rollins' case.
May I respond, Your Honor?
Aye.
I'm sorry, Your Honor. I think you're frozen.
I am. I'm having I live a little bit out in the Tules, and sometimes I have a bad internet connection. I think I got you now. Go ahead, Mr. Aragon.
Again, this has nothing to do with her emotion. This has to go with a whole nother case. In addition, this is still hearsay, as well as lack of foundation, because they never laid the foundation of how she would know about this court case. And again, it's a whole separate court case, still hearsay.
What the court's going to do is sustain the objection as it relates to the emotional state of the victim in this case. I think that is outside the knowledge of this witness, unless there was a statement made, and even then it may potentially be hearsay. The court's going to sustain the objection. You may continue, Ms. Bednar.
Let's move on now and discuss March 5th and 6th. Where were you on the evening of March 5th, the day before Mr. Brackman's death?
The day before Mr. Brackman's death, I was hanging out with my friend Taylor Perkins at the Fry Shack, and we just walked around the mall doing normal teenage stuff.
Who did you see at the Fry Shack on March 5th?
On March 5th, I saw my former mock trial team and Alex Cifuentes.
What were you doing the morning of March 6th?
The morning of March 6th, I was going to head over to my friend Taylor Perkins's house, but then I realized I didn't have my phone and I realized I lost it.
When was the last time you remembered using your phone on March 6th?
The last time I remember using my phone on March 6th was at the Fry Shack.
What did you do after you had realized your phone was missing?
Well, Taylor and I agreed that we should go look for it, so we just ditched school. I mean, all of our classes were raw. It wasn't like we were missing anything, so we just walked around, looked for my phone.
Let's move our attention to the screenshotted text conversation that Alex Cifuentes testified to. Did you send any text to Alex Cifuentes?
No, I would do no such thing. I wasn't ever friends with them. I didn't like them. I would never do a thing like that.
Thank you, Your Honor. No further questions.
Cross-examination.
Yes, Your Honor. Thank you. Good morning, Ms. Becker.
Good morning.
Let's start by talking about the difficult relationship you had with Coach Brackman. You two didn't get along very well.
Yes, huge work ethic, but at the end of the day, we learned to tolerate each other because, well, it was the best for the mock trial team.
Right, but you would argue at almost every practice, correct?
Yes, we would argue.
You felt that Coach Brackman would unfairly accuse you.
I mean, yes, I didn't agree with how he was critiquing me.
And like you said, that he always criticized you.
Yes, he did. I just didn't agree with him, and I feel that's normal.
And a month before the regional mock trial tournament, Coach Brackman, demoted you down to the B team.
Yes.
Which was a team you felt was full of losers. Was that the word that you used?
Yes, that was.
Objection, hearsay.
Overruled.
Which was a team you felt was full of losers. Was that the word that you used?
I was just really frustrated because I had these amazing roles, and now I was crossing a dog walker. But I
used those words. So this was upsetting to you.
I'm sorry, can you repeat that? You cut out.
Yeah, sorry. So this was upsetting to you.
I mean, yeah, crossing a dog walker isn't the ideal role.
Right. You tried everything to convince Coach Brackman to put you back on the A team.
Yeah, I wanted to be back on my spot.
But this wasn't even the worst of your relationship.
I haven't testified to this exact statement, but I can if you would like me to.
Well, I just need a yes or no. This wasn't even the worst of your relationship, correct?
Sir, I can't say yes or no unless you would like me to testify to this.
All right, well, moving on, because after the regionals tournament is when your relationship reached a boiling point, correct?
Yes.
Let's talk about what happened. You performed very well at the regionals tournament.
Yeah, I thought I did pretty well.
But you did it by going against Coach Brackman's advice.
Yeah, like I said, mock trial is more of an art rather than something you can read off of a script.
Right. And this didn't really sit well with Coach Brackman.
Yeah, no, it didn't. I could see how that's frustrating, how I didn't go by his corrections.
Right. He told you didn't deserve the Best Attorney Award.
Yes, that was very
Objection,
heartbreaking.
hearsay.
Response.
Your Honor, this is not hearsay because it's not being offered for the truth of the matter. We're not trying to prove Ms. Becker did not deserve the Best Attorney Award, but rather the effect the statement had on Ms. Becker and what she did after hearing it.
Reply.
Your Honor, I'm objecting to the statement of what Brackman had said, and this is not being used for the effect on the listener. This is using to assert whether or not this statement was in fact being used for the truth.
All right, it's a close call, but the court's going to admit this because I do think it goes to the issue of the effect on the witness in this case, and the court's going to overrule the objection. You may continue.
Thank you. He told you didn't deserve the Best Attorney Award.
Yes, and like I said, that was not the ideal feedback I was looking forward to.
Right, that made you really angry.
Yes, that made me upset. I mean, I just won an award.
Right, you called him the worst coach in the state.
Yeah,
objection, hearsay.
It's a statement by a party opponent. It's overruled. It's not hearsay.
You called him the worst coach in the state.
Yes, but that obviously wasn't true. I mean, we got to state because of him. He put us in a competitive spot. He was like the glue to mock trial that made us all stick together.
Okay, but you ended up storming out of practice, correct?
Yes, I was very upset.
You saw Coach Brackman's porch.
Yes.
And wrote in giant letters across the hood, Worst Attorney Award.
This was not my brightest moment, and I deeply regret doing that. That was devastating to me for why I did that, and I would like to deeply apologize to him.
But you still did that, correct?
Yes, that is correct.
Coach Brackman was livid.
I'm sorry, I don't understand what you're... Oh, excuse me. Yes, he was very upset with me. I mean,
Right. He yelled at you that I've had enough.
Yes, he did say that.
You're off the team.
Yeah, he did say that, and obviously that was so valid. I mean, I wrote on his car.
Right, but that made you mad.
Yeah, that upset me. I mean, it would upset anyone.
Right, you were devastated. Correct?
Yes, I was devastated in the moment.
You went home and talked to your mom.
Yes, I did talk to my mom.
Told her that you were kicked off the team for no good reason.
That is correct. I was too embarrassed to tell her what I've done.
Right, you didn't tell her what you have done to his car.
Yeah, I mean, it was embarrassing.
And not only did you fail to tell her the truth, but you swore to your mother that you'd get back at Coach Brackman if it was the last thing you did.
Objection under 403.
Response.
Your Honor, this isn't under 403. Again, it just goes to show the motive that the defendant had with the victim.
Court's going to overrule the objection.
And not only did you fail to tell her the truth, but you swore to your mother that you'd get back at Coach Brackman if it was the last thing you did.
Yes, that was in the heat of the moment, but I obviously revoked that because I tried to make amends with him and not do anything like that.
That's a yes, you told your mother that you get back at Coach Brackman if it was the last thing that you did?
I believe I answered that with a yes or no.
Perfect. Thank you. No further questions, Your Honor.
Redirect.
Yes, Your Honor. Miss Becker, how did you feel after you had vandalized Coach Brackman's car?
I was so upset with myself when I realized that the marker was permanent. I would never mean to do anything to Mr. Brackman like that. That was permanent. You know, I felt really bad. And afterwards, I even offered to get a job to get his car repainted or chip it off. It was horrible. And it was not my best moment.
Thank you, Your Honor. No further questions. My apologies. Did you hear that, Your Honor?
No, I did not. The internet problem, I'm having a little issues with it here, but I did not hear your last question.
Oh, my apologies. There were no further questions, Your Honor.
Okay, got it. All right. This witness may then be excused. Oh, pardon me, recross-examination, I'm sorry.
No questions, Your Honor.
All right, thank you. The defense may call their next witness.
The defense calls Taylor Perkins to the stand.
All right, thank you.
Good morning, Ms. Perkins. Please state your name and spell your last for the record.
Taylor Perkins, Perkins.
Your Honor, am I supposed to wait? Never mind. Sorry, I wasn't aware that the cross attorney had turned on their camera.
You got it.
Ms. Perkins, why are you here today?
I am here today because my best friend Avery Becker is being accused of murder.
How do you know Mackenzie Brackman?
Mackenzie Brackman was the mock trial coach for Colorado High School's mock trial team. I was on the mock trial team when I attended CHS.
Was coaching mock trial Mr. Brackman's only job?
No, actually, Mr. Brackman was also a defense attorney.
Do you know who Blair Rollins is?
Blair Rollins is one of my peers, or was one of my peers at Colorado High School.
To your knowledge, did Mr. Brackman ever interact with Blair Rollins?
Objection, Your Honor. Relevance and hearsay.
Response.
Your Honor, to the relevance objection, one moment. If we apply the relevance test, this goes, excuse me, Your Honor. If we apply the relevance test, it has the tendency to make this fact more probable that Mr. Brackman did know Blair, and its fact is in consequence of determining the fact that there could be an alternative suspect. As to hearsay, Your Honor, Ms. Perkins is only testifying to things that she would know in her personal knowledge, and there is no specific statement being offered.
Correct. How is knowing Mr. Rollins relevant? The fact that the victim in this case knew Mr. Rollins, how is that relevant?
It provides an alternative suspect to this case.
What I'll do is I will overrule the objection, provided the question is framed with respect to the time period that's in question here. And then assuming this is foundational, I'll let you ask that.
Ms. Perkins, to your knowledge, did Mr. Brackman ever interact with Blair Rowlands?
To my knowledge, well, I should say it's common knowledge across Colorado High School that
Again, to hearsay, this is a lack of foundation. They've not established how this witness knows that Coach Brackman has talked with Mr. Rollins before. That has not been clearly established and no foundation has been laid.
All right. The issue here, I'll first of all overrule a hearsay objection. It's not hearsay, but the issue is that she's testifying it's common knowledge, and the objection, I think, more properly framed is foundation with respect to her saying common knowledge. So Ms. Latek, if you want to respond to that.
Ms. Perkins has knowledge of this because she went to this high school. Blair Rowlands also went to this high school, so it would be reasonable that she had common knowledge of what was going on at this high school.
What the court will do is I'll permit the question as long as the foundation is laid that you just talked about. In other words, she has to establish those very things. If she does that, then I'll let her continue to answer questions from you. So go ahead, Ms.
Ms. Perkins, do you know Blair Rowlands?
Yes, Blair Rowlands was one of my peers at Colorado High School when I attended Colorado High School.
To your knowledge, did Mr. Brackman ever interact with Blair Rowlands?
It is common knowledge across Colorado High School that Blair Rowlands had total beef
Sorry,
with
Honor, I'm
Coach
going to have
Brackman.
to object to lack of foundation. You specified that they needed to add a time and they did not do this.
And Ms. Latek, what I'm talking about is she has to testify about why it's common knowledge. She just said it's common knowledge. What's the basis for her opinion that it's common knowledge? That's the area that you have to lay the foundation for if you wish to continue with this line of questioning. She simply can't say it's common knowledge. What's the basis for her saying it's common knowledge? So that's the ruling of the court. You may continue.
Ms. Perkins, why is it common knowledge?
It's common knowledge across Colorado High School. I mean, it's sort of like the school scandal. And, you know, most students have knowledge of that. It's pretty frequently discussed.
How did Mr. Brackman know Blair?
Mr. Brackman knew Blair. Like I was saying, it's common knowledge across Colorado High School that Blair Rowlands had total beef with Coach Brackman because, to my knowledge, Coach Brackman had lost the case that sent Blair Rowlands' father to prison while Coach Brackman was performing his role as a defense attorney.
Was Blair Rowlands ever tied to your mock trial team besides Mr. Brackman?
So being on the mock trial team, I was able to observe a lot of the relationships and friendships of my teammates. And from what I could tell, Blair Rowlands was friends with Alex Fuentes, another student on the CHS mock trial team.
Let's talk about Avery Becker's and Mackenzie Brackman's relationship. Did they get along?
Coach Brackman and Avery did have quite the feud that would be, prevalent during these meetings. But, being on the mock trial team and being Avery's best friend, it was really easy for me to see that their feud didn't really go beyond anything more than just a difference between what they thought good work ethic looked like in mock trial.
Were these interactions ever upsetting to Avery?
Avery would become visibly bothered by, some of Coach Brackman's remarks, but it never bothered her enough anymore than to just play some pranks on Coach. And personally, I found the pranks that she played pretty funny. They made mock trial entertaining.
What happened after the regional tournament?
To my knowledge, after the regional tournament, Coach Brackman and Avery had another one of their disputes or something over good work ethic, and Avery left practice and ended up writing something on Coach Brackman's car in what she thought was promo marker and told me, my mistake, what she thought was expo marker. That's an important clarification. And she told me that same night that she thought it was expo marker.
What happened to Avery after this?
Well, after this, Avery was visibly remorseful, but Coach Brackman still decided to remove her from the mock trial team.
Let's talk about the day before Mr. Brackman died, March 5th, 2020. What were you doing that day?
On March 5th, 2020, Avery had swung by my house Then we later went to go grab something to eat at the Fry Shack. And after we left the Fry Shack, we just sort of hung out at the mall.
Who else saw you at the Fry Shack with Avery?
Well, we were at the Fry Shack. We actually ran into most of the mock trial team, including Alex Fuentes.
How did Alex and Avery get along?
Yeah, Alex and Avery never seemed to get along great from what I observed as a fellow mock trial member, but being on the mock trial team, it was pretty easy to deduce that Alex had something to gain from Avery not being on the team because, Avery got fantastic roles. She was extremely talented.
What were the interactions like between Alex and Avery that evening?
Well, so the entire team was sympathizing with Avery. She'd just been kicked off the team. But Alex was going about this pretty passive aggressively.
What happened as a result of this?
As a result, Avery got up and went to the bathroom, and I did see her leave her phone on the table.
What did you do after Avery came back?
Well, after Avery came back, we had no interest in being at the Fry Shack anymore with Alex being there. So we just decided to immediately leave. I didn't think to grab Avery's phone that was still on the table, and I didn't see her grab it either.
Let's talk about the day Mr. Brackman died. What were you doing on March 6, 2020?
On March 6th, 2020, Avery and I were looking for her phone.
How did you know Avery's phone was missing?
So Avery usually took me to school every morning. And the morning of March 6th, 2020 was no different, except I had texted Avery earlier that morning and she never responded. So when Avery came to pick me up to take me to school later that day, I sort of jokingly mentioned that, she hadn't responded to my text. And that's when she realized that she didn't have her phone on her.
Is it normal for you two to text often?
Yeah, Avery is my best friend. We text pretty frequently.
How did you go about finding Avery's phone?
We spent the day retracing our steps. So we went to the Fry Shack and to the mall. And the entire time I was trying to call and text her phone in hopes that maybe it would make some sort of noise or someone would pick up.
Who else saw you and Avery together the day Mr. Brackman was murdered?
So we went to the mall and the Fry Shack. And while we were at the Fry Shack, we checked with the afternoon shift staff. And we actually ran into some members from the mock trial team again. They had left practice early because Coach Brackman hadn't shown up. And like the rest of them, we later found out that unfortunately our coach had passed away.
No further questions, Your Honor.
Thank you. Cross-examination.
Yes, Your Honor. Good morning, Ms. Perkins.
Good morning.
I'd like to start off by talking about your relationship with Avery Becker. You and Avery Becker are friends?
Oh, yeah. Avery and I are friends.
Right, best friends.
Yes.
And you were both on the mock trial team?
Yeah, we were both on the mock trial team. I was really only there because Avery was there.
Right, and Avery often butted heads with Coach Brackman?
Sure. They had a bit of a feud going on, but like I said, it didn't really seem to be anything more than just a difference between what they thought good work ethic should look like.
Right, he was always giving her a hard time about something, though.
Yeah, he didn't like that Avery was able to show up to practice unprepared and still be the best on the team.
Right, so this eventually led to Coach Brackman demoting Avery to the B team.
It did.
And things didn't really get better between Avery Becker and Coach Brackman.
I wouldn't really say that things ever got better.
In fact, they got worse.
Well, I don't know if they got worse. They always had just a bit of a dispute between, about work ethic.
Right. Well,
that was a pretty consistent thing.
My apologies. Well, let's talk about the day after Avery Becker vandalized Coach Brackman's car. During practice, Coach Brackman was being pretty mean to Avery.
To my knowledge, yes.
Telling her she didn't deserve mock trial awards that she had won at the tournament.
Objection, hearsay.
I wasn't there.
I'm sorry, it was a hearsay objection. Counsel, response?
Your Honor, this is not hearsay. This is not being offered for the truth of the matter. We're not trying to prove the fact that the defendant didn't deserve the awards, but rather to show that what she did after hearing the victim talk to her that way.
Thank you. Reply?
Your Honor, the statements that are being said excuse me if you can hear my dogs. The statements are being made to prove that Avery is going to go do something because of these statements.
The court's going to overrule. I don't think the objection with respect to the issue of hearsay. I don't think they are being offered for the truth. They're being offered to establish a reaction on her part. So the court's going to overrule the objection. You may continue.
Telling her that she didn't deserve the mock trial awards that she had won at the tournament.
Well, I wasn't there that day, but I do think that that's what happened.
All right, and this upset Avery.
Again, I wasn't there, but I'm pretty certain it upset Avery based on, our interactions after that.
Yes, and I'm using your words here. So Avery wrote on Coach Brackman's car with a marker?
Yes.
And Coach Brackman found out?
Well, of course. Yeah, that was his car.
Yeah, and kicked Avery off the team.
He did?
Avery didn't think that it was fair she got kicked off.
I don't know what Avery thought, but I personally didn't really think it was fair. With Avery off the team, we wouldn't be able to go to the state tournament.
So that's a yes. Avery didn't think it was fair she got kicked off.
I'm not sure, but I think that that's a reasonable assumption.
Right. Well, I'm using your words here. And Avery liked to play some pranks on the coach, correct?
Sure. Avery played some pranks sometimes.
And Avery just wanted to let off some steam.
Yeah.
And just freak Coach Brackman out.
Sure.
But her plan that day with the car backfired.
Yeah, it did.
However, Avery was desperate to get back on the team.
Well, of course, Avery was extremely talented in mock trial, and it seemed to have meant a lot to her.
Right, but you didn't know what Avery had planned to get back on the team.
Well, we actually did discuss that. We talked about ways that Avery could get back on the team, and one of those ways was texting everyone on the team.
Right, and you knew that she could be rash.
Yeah, Avery could be rash, but man, most students at Colorado High School could be rash. We're kids.
Speaking of rash, let's talk about the day leading up to the murder. The day before Coach Brackman was murdered, you were with Avery Becker, correct?
Yes, on March 5th, 2020, I was with Avery.
Yes, and you went to the Fry Shack that day?
We did go to the Fry Shack.
Right, and you ran into some mock trial people?
Yep.
And Avery got upset?
Yeah, Avery got upset because, Alex was acting sort of funny towards her, being passive aggressive.
Right, and so she stormed off.
Yeah, she excused herself to the bathroom.
And the next day on March 6th, Avery picked you up from your house that morning?
Yeah, she did pick me up from my house.
And it's your position that you spent the day searching for Avery Becker's phone, retracing your steps?
Well, that is correct.
And you maintain that you were nowhere near Coach Brackman's house that morning?
No, we had gone to the mall and the Fry Shack.
Right, so you were nowhere near Coach Brackman's house that morning?
We weren't.
Because you know where Coach Brackman lives?
I have somewhat of a general idea of where he lives.
Thank you. No further questions, Your Honor.
Redirect.
Briefly, Your Honor. Ms. Perkins, how do you know Avery Becker didn't kill Mackenzie Brackman?
I know that Avery didn't kill Mr. Brackman because I was with her on March 6th, 2020, looking for her phone that she had left the previous night at the Fry Shack.
Who saw you that day?
Well, we had gone to the mall, the Fry Shack, and while we were at the Fry Shack, we checked in with the afternoon staff shift and ran into some students on the mock trial team.
No further questions, Your Honor.
Recross examination.
No recross examination needed, Your Honor. Thank you.
Thank you. This witness is then excused. The defense may call their next witness.
The defense calls Professor Blake Van Owen to the stand.
All right, thank you.
Your Honor, before I begin, may I have a time check?
Certainly.
Yes, you do have approximately 15 minutes left.
Thank you.
All right.
Good morning. Please state your name, spelling your last for the record.
My name is Professor Blake Van Owen, VANOWEN.
And what do you do for a living?
Well, I'm a professor, a private investigator, and as well as I sometimes testify in police practices.
What experience do you have with police practices?
Well, my experience began in 2005 when I was part of the Aurora Police Department.
On the Aurora Police Department, what police practices did you gain experience with?
Well, I had experience with false arrests, forensic evidence techniques, use of force, cell tower analysis, crime scene reconstruction, and in general police practices.
You said that you're a professor alongside being a private investigator. What do you teach?
Well, I teach social justice and police practices at CU Denver.
How much experience do you have working as a private investigator?
Well, I have quite a bit. I've testified in court quite a few times. I've testified in district courts of Colorado, Kansas, and Arizona, as well as state courts of Colorado, New Mexico, Wyoming, and Nebraska. I've consulted on more than 100 cases. I've testified 8 times in cell tower, 8 times in crime scene reconstruction, 5 times in cell tower analysis, and I believe 15 times in general police practices. My apologies.
Your Honor, at this time, I move to tender Professor Blake Van Owen as an expert in police practices, crime scene reconstruction, and cell tower analysis.
People.
I have a voir dire, Your Honor.
You may, briefly.
All right. Good morning, Professor Van Owen. I want to start by talking about your experience, and I want to go through some of the things that you've already talked about, so bear with me. I just want to make sure we get this right. First, you have a bachelor's degree from CU Boulder.
Yes, I do.
In English.
Yeah.
After graduating, you joined the Aurora Police Department.
Yes, I did.
Where you worked for a total of 9 months, is it?
Yes.
And does that include the months you spent in the police academy?
I'm not aware of that. I don't think I have previously hadn't made any statement on this, but I can right now if you'd like me to.
Sure. Those first 9 months were part of the police academy?
No, they were not. I went to the police academy beforehand and got a ton of experience. I went for at least a year.
Fair to say, you were never assigned as the lead investigator on a homicide.
I do not believe I previously testified to that, but I can if you'd like me to right now.
So that's a no, Professor? You were never a lead investigator on a homicide?
Well, I have to get permission from you to testify to it if you'd like me to.
Professor, I'm not asking you to make up things outside of your fact pattern. I'm just asking you to say that you weren't
I don't believe that that's in my affidavit, counsel.
You weren't a lead investigator on a homicide or on a burglary.
Counsel, I'm confused. I don't state if I ever was or was not a lead investigator in a homicide or burglary in my testimony. So if you want me to say that I was or was not, I would have to state things outside of my affidavit.
Okay. We can assume it was a no. You never filed a case as a detective, though.
Again, I don't state anything about this, but I can right now if you'd like me to.
Unlike Detective Markowitz, you never testified as an expert when you were a police officer either.
Again, I never state anything about this, but I can right now if you'd like me to.
You never completed any other advanced training through a police department?
I have not testified at anything on this, but I would love to if you'd like me to right now.
So when it comes to police procedure and tactics, your entire foundation is based solely on your 9 months as a rookie cop?
No, I mean, I've also taught as an adjunct facility member at Colorado Community College of the Rockies in police practices. I've done quite a lot actually in police practices. I have quite a background.
Judge, the prosecution objects to this witness being accepted as an expert in the field of police procedure and tactics, crime scene reconstruction, and general investigation procedure. First, talking about police procedure and tactics, this witness has zero training in police tactics or procedure other than basic police academy, and we certainly don't let every police officer testify as an expert for just completing the police academy. Just because this witness teaches a class at a local school on police procedure does not mean that they are an expert in the field or frankly that they have any knowledge on the subject at all. On crime scene investigation and reconstruction, this witness is not a certified crime scene reconstructionist. They have no training in the field from the Colorado Bureau of Investigation. They have not worked as a CSR for any police department. We have not heard about any training in that field at all.
All right. Response from the defense, pardon me, Ms. Kite.
Your Honor, first of all, I would like to make it clear that we're attempting to tender this witness as an expert in police practices, crime scene reconstruction, and cell tower analysis. Opposing counsel quoted some other ones that were similar, but not quite those. And I believe that opposing counsel is objecting to those first two, but not cell tower analysis. So
Your
I'll
Honor,
respond to
I'd
those.
like to add cell tower to my objection as well. She's offered no evidence that she has training in cell tower experience or any certification and the like.
Ms. Brockler, I had given you a chance to speak on that issue. It's now Ms. Kite's turn to talk. So Ms. Kite, you may continue.
Your Honor, pursuant to Rule 702, it is not necessary for a witness to be entered as an expert to have testified as to their knowledge, skill, experience, training, and education, but rather just one of those five. And as the professor testified, she has experience working in police practices. She has also taken classes on police practices. She has taught on police practices at 2 different schools. And as far as crime scene reconstruction goes, she also testified to her experience with that. Opposing counsel was at one point testifying for the witness. The witness never said that she was not a certified CSR. She never testified to being one or not being one. But with her experience with it while she was working for the Aurora Police Department, as well as the previous testimony she's made about it, it can be assumed that she is a certified crime scene reconstructionist reasonably. And with cell tower analysis, again, the witness testified that she has experience working with that from when she was on the Aurora Police Department.
All right, very well. First of all, the court can't assume anything. If it isn't before me in evidence, I can't assume that a witness has done certain things or has been qualified or been certified as a crime scene reconstructionist. But what I can say is that she's testified as an expert in the field of crime scene reconstruction, and cell phone tower analysis on more than one occasion, I believe in different states. And while her experience with police practices and procedures in a practical sense, as the prosecution has pointed out, is not exactly lengthy, the issue here has to go with whether she can be permitted to testify as an expert. And the court's going to find that there has been enough foundation laid. Certainly one can make an argument that it's not extensive, but the court's going to find that there's been enough foundation laid for her to be qualified as an expert in those 3 areas. And the court's going to overrule the objection and permit her to testify in those areas. You may continue then, counsel.
Professor, let's begin by talking about the theory that Detective Markowitz and Ms. Kuzak discussed. Is this a theory that you agree with?
Professor, I think you're muted. Yep.
My apologies. Thank you for pointing that out to me. No, I cannot agree with it at all. The only thing that we can agree with is that someone broke into the house, being Brackman's residence.
Did you find any issues then with the police's investigative methods?
Yes, I found quite a lot. The first most glaring issue that must be addressed is the issue of the police never looking into Avery Becker's alibi.
How should the police have looked into Avery Becker's alibi?
Well, if the police are going to hinge so heavily upon cell tower analysis, they could have at least also used that to check out if Avery Becker, in fact, 1, left her phone at the Fry Shack the day before the murder by subpoenaing, my apologies, evidence from the day before, as well as they could have looked into Taylor Perkins' phone records to see if Avery Becker's alibi corroborated with Taylor Perkins' statement. They also could have looked into the cell tower records of anyone connected to Brackman around his house at the time of the murder.
So, Professor, what does the cell tower data that the police collected reveal to you?
It reveals nothing other than a phone interacted with a certain tower at a certain time. It provides no evidence as to where a person was or even where a phone was at a certain time. It's very general.
What are the issues with cell towers?
Well, a huge issue is that cell towers are very tricky things. Cell towers in a rural area can span 100 miles. In an urban area, they can have a radius to 6 to 7 miles. That's a diameter of 12 to 14 miles. And when you add the fact that these cell towers overlap, that makes them something that's not certain at all. You could be a mile away from a cell tower and connect to one 6 miles away.
Let's move on to the investigation of the crime scene and the physical evidence. Did you find any issues there?
Yes, I found a lot. There was an issue with the ring security surveillance videos, as well as an issue with the knife used in the murder, specifically the origin of the knife, as well as the way that the knife was held. There's also an issue with the screenshots taken by the detective. They have a Celebrate system, which they could have easily used to download all of the contents from Alex Fuentes' phone. But I heard earlier Markowitz testify earlier that they didn't feel the need to ask for this phone when they could have easily done this very quickly. And then there's also just an issue of suspects.
All right, so we'll go through those in a general list, starting with what you mentioned about the ring security system. What were the issues that you found there?
Well, there are three issues, three assumptions essentially. One, Kyle Cusack assumed that, well, essentially the police assumed that Brackman had his ring notifications on, alerting him to an intruder. This is an issue because I also own a ring security system. And I know that you can turn off the notifications. I do it a lot when Christmas comes around and, you know, there's tons of packages and you don't want your phone lighting up like a Christmas tree while you're teaching. But they never looked into that. Markowitz never got the data from Brackman's phone to see if these notifications were in fact on. As well as there is an assumption that Brackman even had his phone on him, as well as an assumption that once Brackman, if he even was alerted to this, went down to confront the intruder.
Why is it significant that the victim may not have seen these ring notifications in time or at all?
Well, the police's version of the case hinges upon an altercation between Brackman and an intruder. If Brackman was not alerted to an intruder in his presence, that would mean that no altercation occurred. And instead, this wouldn't be some sort of altercation that led to a stabbing. It would instead be planned murder.
You also mentioned that you had two issues, I believe, with the conclusions Kyle Cusack drew about the knife. What were those two issues you had?
Well, there was an issue with the origin of the knife and also the way that the knife was used. Both, again, came from assumptions.
What was the issue with the origin of the knife?
Well, Kyle Cusack saw a knife block with a missing slot and immediately assumed that this knife came from this knife block, meaning that Brackman took a knife from his residence to defend himself if an intruder broke in. The issue is that there is no definitive way to tie this knife back to this knife block, so there is no definitive proof that this knife is in fact from Brackman's residence, meaning that there is no definitive proof that Brackman armed himself.
Does the knife match the other knives in the knife block?
No, it's not.
You also said that there was an issue with the way of the holding the knife, I believe. Could you elaborate on that, please?
Yes. So Cusack and the police believe that, opine without support, that the knife was held the intruder stabbed Brackman in bear hug fashion. So essentially the knife would be held like this, kind of like you see in the Psycho movie where the knife blade is facing the intruder's arm. The issue is for this to happen, they would be stabbing down kind of like this. It's very uncomfortable. It makes more sense because of the way that the knife handle is, that the knife would be held like this with the blade facing out. If this happened, that would mean that the intruder would be standing over Brackman, who was probably in a seated position, and stab him in the back from behind.
All right, Professor. You also mentioned that you did investigative work into other suspects. What did that work find?
Well, even in my partial investigation, at least I looked into more suspects than the police. I found someone named Blair Rowlands.
And how is Blair Rowlands connected to this case?
Well, Blair Rowlands has multiple connections. One, Blair Rowlands is friends with Alex Fuentes. Two, Blair Rowlands was absent from school the day of the murder. Three, Blair Rowlands is the same height and build as Avery Becker. And four, Blair Rowlands has a negative relationship with Mr. Brackman.
What was that negative relationship with Mr. Brackman?
Well, this negative relationship being that Mr. Brackman defended Blair Rowlands' father, Jonathan Rowlands, in his murder trial. And Mr. Brackman lost this murder trial.
Have you watched the recording for that murder trial, or how do you know about it?
Yes, I watched all the court proceedings from the murder trial. Earlier in the trial, Blair Rowlands testified for their father in their father's defense. And so they were there during their father's sentencing.
Have you personally reviewed the audio file labeled Exhibit 22?
Yes, I have.
And what is Exhibit 22?
Well, it's audio clip after Jonathan Rowlands court proceedings after Jonathan Rowlands was found guilty of murder. He yells out at Brackman, and it's pretty terrifying.
Is Exhibit 22 an accurate copy of the recording of that statement that you used in your investigation?
Yes, it is.
Your Honor, at this time I move to admit Exhibit 22.
People.
Yes, Your Honor, I'm objecting to hearsay. Exhibit 22 is a audio clip from a different trial involving Jonathan Rowlands and comments that Jonathan Rowlands makes on the audio clip about Coach Brackman or Mackenzie Brackman. And so that is an out-of-court statement here and also hearsay because that is not a party opponent statement.
Ms. Kite, how do you respond to the hearsay objection as it relates to statements made by Mr. Rowlands Sr.?
Your Honor, these statements are not hearsay because they are not being used for the truth of the matter asserted, but rather the effect on the listener, with that listener being the alternate suspect, Blair Rowlands, who the professor just testified was present at this court recording, and this would have an immense impact on Blair Rowlands' potential motive.
Your Honor, I can respond to that.
And Ms. Brockler, if you will reply to that for us.
Yes, Your Honor. By admitting these audio recordings, one, I anticipate that Mr. Rowlands will say something to the likes of causing harm to Mr. Brackman. That is quite literally submitting them for the truth of the matter, that he means to do this and intends to do this, and that Blair Rowlands hearing this hears the truth of his father. They're submitting them for the truth of the matter.
Your argument is that they're being submitted for the truth of the matter as it relates to Jonathan Rowlands' statement that he made. They're offering it for the purposes of what Jonathan Rowlands. So while your argument is relevant, I think, is germane to the issue of Jonathan Rowlands, and there may be more of an objection raised to the court admitting that, it's being offered for the purposes of showing not so much for the truth, but the effect on Blair Rowlands. Understanding all that, I think the court will admit the tape at this particular point in time, finding there is at least a basis for it, understanding the hearsay objections that have been raised and the reasons behind those. The court's going to overrule those objections and will admit the tape itself. So objections overruled. Thank you.
Permission for my co-counsel to share their screen and play this exhibit for the jury.
It's been admitted. It may be published.
I'll get you back, Brackman, if it's the last thing I do.
Let the record reflect that my co-counsel has now stopped sharing their screen. Professor, what was the significance of that recording to your investigation?
Well, Blair Rowlands is testifying for their father. This is a sentiment that their father holds, and it's definitely very, it would have a huge effect on a child for their father to be put away for murder. And in this, I think it would definitely—
Your Honor, improper expert opinion. Professor Van Owen is speculating on how this affects Blair Rowlands as a child.
Ms. Kite?
Your Honor, this witness, this is not an improper expert opinion. This witness has been entered as an expert in police practices, which the defense would argue includes motive and having an understanding of how motive works. And therefore, it's reasonable for this witness to testify as to how hearing a statement like this led her investigation as a private investigator in considering Blair Rowlands an alternate suspect.
She's been admitted as an expert in the field of police practices, crime scene reconstruction, and then cell tower information. What she's being asked to opine on right now is the state of mind of Blair Rowlands. She has never been qualified as an expert in that. I don't believe anybody is an expert on interpreting the state of mind of others. The court's going to sustain that objection.
Yes, Your Honor. Now, Professor, with all of these different elements that we've discussed in mind, what is your theory on the case?
Well, my theory is that either Alex Fuentes stole Avery Becker's phone and gave it to Blair Rowlands in order to implicate Avery Becker in the murder of Coach Brackman, which Blair Rowlands carried out, or that's too cloak and dagger for you. Blair Rowlands took Avery Becker's phone, which is perfectly likely that Blair Rowlands could have been at the Fry Shack, and then murdered Mr. Brackman, implicating Avery Becker.
No further questions, Your Honor.
Cross-examination.
Yes, Your Honor. Professor, you just testified to a whole bunch of opinions, but before we get to your findings in this case, it's important to look at why you are here today. You were hired by Avery Becker, correct?
Yeah.
To offer opinions on behalf of the defense.
Yes.
And you were paid quite well for those opinions.
Well, just like investigators get paid to investigate, private investigators get paid to privately investigate. So yes, I got paid for my work.
And for your testimony today.
Well, yes.
In fact, you're on the clock right now.
Yes, that's true.
Let's talk about your rates. You make $225 an hour for your research.
Yes.
And you get paid even more than that to testify to your opinions in trial.
Yes, but I would like to make it clear I only make about $6,000 to $10,000 per case. I'm making about $7,000 in this case. So it's not like I'm making a ton of money.
So let's talk about those opinions that Miss Becker paid so much for. You would agree that it's important to consider all of the evidence found at the scene.
Yes, absolutely. That's what an investigator should do.
And not place any emphasis on one piece of evidence over all others.
Yes.
The most basic principle of being an investigator is to never make assumptions, never assume.
Yes.
Now, you and Detective Markowitz agreed that someone, an intruder, entered the home unlawfully.
Yes.
Where you two disagree is whether the victim was alerted to the intruder or not.
Yes.
You believe the victim was not aware of the intruder before being stabbed.
Yes.
Even though Detective Markowitz found scuff marks by the door indicating a struggle.
The issue with these scuff marks are that they do not indicate a struggle.
It is your testimony.
I don't know when they came from.
I'm sorry, I didn't catch your last part there.
We can't say if they indicate a struggle or not. We do not know when the scuff marks were made.
It is your testimony today that these scuff marks did not indicate a struggle?
Well, Kuzak believes that they indicate a struggle. I do not.
In this case, you made a statement?
Yes, I did.
And in that statement, you were thorough?
Yes, I was.
You were honest? Professor, you were honest?
Yes, I was honest.
You were complete?
Yes, I was.
If there's anything in your investigation, it's found in your statement?
Yes.
And you signed your statement in this case?
Yes.
So I'm going to read line 93 from your statement. First,
Objection, Your Honor. Improper impeachment. This witness should be directed to her affidavit so that she can follow along and confirm that this is indeed her statement, whether through screen sharing or her own copy.
Bill.
Professor Van Owen, if you have your copy in front of you, that'd be great.
I do not. I'm a witness, so I do not have my affidavit, nor do I have my direct in front of me.
Okay. I don't have an online copy here. I have a form in front of me. Can I read from that, Your Honor?
Well, I think what you can do is you can ask her if she made the following statement without reading from the statement. If she can't remember, then you're obligated to show her that statement. If she doesn't have it in front of her, then you're in a bit of a pickle. But you can ask her did you make the following statement without reading from the statement itself. And then if you want to take it further, you can read this statement to her if she in fact has the ability to get the access to the statement. You understand what I'm talking about, the counsel, pardon me?
Yes, Your Honor. I've already confirmed that she made a statement in this case. I've confronted her with her testimony.
Okay. So you confronted her with the testimony you want to inquire about specifically from the document?
Sure, Your Honor. I think someone from my co-counsel can screen share.
I think you're missing my point. My point is you can ask her in a general sense, did you say X, without reading from the document? Then she can, depending on what her answer is, then you can point that to her and say, here's the statement. Do you understand what I'm saying?
Yes, Professor.
You may,
Your Honor.
That's okay. I'll take the promotion. You can cross-examine her on those lines. You may proceed.
Professor, you stated that the only apparent evidence in this case or of a struggle were these scuff marks in this case, correct?
Yes, but I did not say that the scuff marks indicated a struggle, meaning that a struggle did in fact occur, which is, I think, what you were implying. And no, a struggle did not occur. They can possibly indicate that there was a struggle, but a struggle did not occur.
Your next opinion is in regards to the murder weapon. First, you believe that the intruder brought their own knife because they went to the victim's home with the intention of killing the victim.
Yes.
You assume this because the knife they used to stab the victim is a different brand than the knives in the knife block.
It's not so much of an assumption. It's just that this could possibly have happened. There's no evidence pointing to that the knife came from this knife block in the home. So yes, it is very likely that an intruder brought this on.
Let's see what the evidence tells us from the scene. I'm showing you it's already been admitted as Exhibit 10. You would agree, Professor, that this intruder does not have a knife in their hands.
I haven't seen the intruder yet.
Professor, the intruder is in Exhibit 10 right
Yeah,
there.
I now see the intruder. The video hadn't got to the intruder coming in front of the door yet. I haven't previously testified to this, but I can if you'd like me to right now.
Professor, I'm just asking you to look at the video and tell me if the intruder has a knife in their hands.
I mean, it's perfectly possible that they're hiding the knife behind their back. I can't say that there's not a knife on them, but yes, there's not a knife in their hands.
So you could assume that it's somewhere else on their person.
Oh, yes, it's perfectly possible that it's somewhere else on their person.
But as an investigator, you should never assume, correct?
I'm not so much assuming as I'm looking at evidence and putting together the most logical hypothesis.
Professor, you just told me you were assuming.
No, it's a hypothesis, not an assumption.
Professor, how big was that knife?
I do not believe, you can refresh me on that if you'd like me to.
Okay, if both Detective Markowitz and Kuzak's report indicate that the knife is 12 inches, you'd agree with that?
Yes, I would.
And 12 inches is about this big. I'm indicating that with my hands for the court reporter.
I think 12 inches is about this big.
Great. So you want the jury to believe that someone is carrying a knife this big in their pocket?
I'd never said in their pocket.
Or somewhere on their person?
Yeah, it's perfectly possible that they're hiding it somewhere on their person. It could be in their pants. It could be inside their shirt, like rolled up in another shirt.
Let's talk about some other things that didn't happen in this investigation. Part of your opinion in this case is listing all the things that Detective Markowitz could have done but didn't do.
Yes, that's my job to look over police reports.
Detective Markowitz did not follow up on Blair Rollins.
Yes.
You believe that you uncovered a person with an even bigger motive to kill Mackenzie Brackman than Avery Becker.
Well, yes, someone whose father was put away for murder, who testified in defense of their father, definitely has a bigger motive than someone who got kicked off of a mock trial team.
Blair Rollins wanted revenge against Mackenzie Brackman.
I think it's perfectly reasonable to think that, yes, Blair Rollins would want revenge against Mackenzie Brackman.
And he had ample opportunity to commit this crime because he was a student at Colorado High School.
Well, also because he was missing the day of school, the day of the murder.
Yes, missing the day of school. He had the same build and body shape as the person in the ring video.
Yes, and his house goes through the same exact route as the phone, if we're going to trust cell tower analysis.
And Blair Rollins was also friends with Alex Fuentes.
Yes.
Aren't all those same facts true about Avery Becker, though, Professor?
Well, just because they're true about Avery Becker as well just means that both are just as likely as a suspect, meaning that the burden of proof, there's still a lot of doubt.
Avery Becker was also absent the day of the murder?
Yes.
Avery Becker also had a motive to commit this crime?
Not as strong as Blair Rollins.
But she had a motive?
Yes.
Thank you. No further questions.
Redirect.
No, Your Honor.
This witness may then be excused. Does the defense have any additional witnesses?
No, Your Honor. The defense rests.
Thank you. The defense rests. Are the parties then ready to proceed to closing argument? People?
Yes, Your Honor.
And will the people be reserving a rebuttal closing argument?
Yes, Your Honor, that would be great.
All right. The people may proceed to make their initial closing argument.
I would get back at him if it was the last thing I did. This is the promise that Avery Becker made to her mom after getting kicked off the mock trial team. And on March 6, 2020, Avery Becker fulfilled her promise and resulted in the death of Mackenzie Brackman. Avery Becker skipped school the day of March 6, which is abnormal for a day in March, as you heard Avery Becker say. She went down to Mackenzie Brackman's house at 444 South Flower Street with the intention of breaking in and vandalizing the house, just like she did his car. She was surprised to find him home that day, though, because she thought he was going to be at work. She was greeted by Mr. Brackman, who knew that she was coming into his house. He got an alert. He greeted her with a knife. They grappled over this knife, and Avery Becker won control of that knife and ultimately stabbed Mr. Brackman before fleeing the scene. We bring forth 2 charges in today's case: burglary in the 2nd degree and murder in the 1st degree. Now, in just a few minutes, we're going to go back there and ask you to deliberate on these charges and find Avery Becker guilty of both crimes. So let's break down what those charges mean. Burglary in the 2nd degree means that Avery Becker broke into the house of Mackenzie Brackman unlawfully with the intention of causing criminal mischief, vandalizing the place. Now, this is the more complicated charge, is murder in the 1st degree in this case, because this case is unique, where in order to find Avery Becker guilty of murder in the 1st degree, she did not have to intend to kill Mr. Brackman. His death resulted in the actions of her burglary that she started. You do not have to find that she had an intent to kill him. Let's go through the facts of this case. You learned from Detective Markowitz that Avery Becker was at the scene of the crime at the time of the murder. We learned this through the call detail records. That is a GPS location mapping out where Avery Becker went on her route. You also learned that Avery Becker had the motive to commit this crime. She was kicked off the mock trial team. She was moved to a team full of losers. That made her mad. We learned in the past that when Avery Becker gets mad, she takes action on that. She vandalized Coach Brackman's car. She did the same thing today. She told Alex Cifuentes, I'm going to go down to Coach Brackman's house and I'm going to vandalize it. Even if you don't believe those text messages, she told her mom. She told her mom that she would get back at Coach Brackman if it was the last thing she did. And she followed up on that promise. You heard from Kyle Kuzak that this was a burglary gone bad, resulting in that 2nd degree burglary charge turning into 1st degree murder. You also heard testimony from Taylor Perkins today, who corroborates the alibi of Avery Becker. But there's one really important thing to point out here. Taylor Perkins is best friends with Avery Becker. Taylor Perkins would do anything for Avery Becker. They lost their spot on the mock trial team to give it up for Avery Becker. They're devoted to Avery Becker. They idolize Avery Becker. You have to throw their testimony away today. Now, the defense is going to come up here and tell you that this was a rushed investigation, that the evidence doesn't point to you. You need to listen to the call detail records. You need to listen to the concrete evidence that Detective Markowitz has. You need to find Avery Becker guilty because she was rash and she was vengeful. And she killed Mackenzie Brackman on March 6, 2020.
Thank you. Does the defense desire to make closing argument?
Yes, Your Honor.
You may do so.
A good investigator investigates. They don't take the path of least resistance at the expense of the case. Today, Detective Markowitz told you how crucial it is for an investigator to follow up on all possible leads, a reasonable rule to go by. In this case, however, she chose not to, and it is because of that failing that Avery Becker sits before you today. Almost immediately after arriving on the scene and observing the victim's body, Detective Markowitz recognized the victim, Mackenzie Brackman, a criminal defense attorney. The detective had an immediate realization. It's not uncommon for a criminal defense attorney to be targeted by a disgruntled ex-client. However, Detective Markowitz identified an easier pathway to investigate, one that thrust itself into the detective's lap, one that went through Alex Cifuentes. You heard how this very first person that the detective called gave her the biggest break in her case. Yet, Detective Markowitz did nothing to verify this big break, although it would have been exceedingly easy for her to do so with her special training and the resources of the police department. She never even asked Alex Cifuentes to bring the phone in. The prosecution carries the burden of proof in this case. they must prove to you beyond a reasonable doubt that it was Avery Becker who intruded Mr. Brackman's house and caused his death. If you, members of the jury, have any reasonable doubt that Avery committed these crimes, if there is any part of the prosecution's case that falls through or any other explanations for what happened on March 6th, you must find Avery Becker not guilty. So what has the prosecution provided us with today in their attempt to reach this high standard of proof? There are two main pieces of evidence that the prosecution has presented to try and connect Avery to these crimes. First, the screenshots, which could have easily been faked and could have easily been verified, yet nobody bothered to do so. And second, the call detail records, which aren't that accurate to begin with, and that show us that Blair Rowlands, an alternate suspect that the police department failed to properly investigate, lives in the same area and next to the same cell tower antenna as Avery Becker. Let's look at what Avery was really doing on March 6th. To talk about March 6th, though, first we must talk about the night of March 5th. We learned that Avery went to the Fry Shack with her best friend, Taylor Perkins. Alex herself told you about how she played a game on Avery's phone that night. Sometime after that, Avery realized that her phone was missing. Alex had Avery's phone, then Avery's phone went missing. Alex was friends with Blair Rowlands, an unlocated suspect. Alex Cifuentes, who was considered a suspect by the police, although Detective Markowitz conveniently forgot about that on the stand today, was best friends with Avery Becker per her own testimony, but today is testifying against that best friend. Avery and Taylor told you about the envy that Alex showed towards Avery. Alex was the last one to have Avery's phone, and the next day, Alex gave Detective Markowitz her biggest break in the case with screenshots that nobody bothered to verify. Avery and Taylor spent March 6th, the day of Mr. Brackman's murder, looking for Avery's phone. This was confirmed by the unanswered calls from Taylor to Avery throughout the day as they tried to locate her phone in the mall. Professor Van Owen also investigated this case, and unlike Detective Markowitz, she decided to follow up on all possible leads. Her investigation led her to Blair Rowlands, the daughter of one of Mr. Brackman's ex-clients that got convicted and sentenced to prison for murder. You heard Exhibit 22. Jonathan Rowlands, Blair Rowlands' father, said, "I'll get you back, Brackman, if it's the last thing I do." When there are at least two people who fulfill the prosecution's argument of means, motives, and opportunity, and the police failed to properly investigate other suspects, the prosecution fails to meet that high standard of proof. The police department didn't bother to verify the screenshots. They didn't bother to investigate viable alternate suspects. They didn't bother because the moment Detective Markowitz got her biggest break, she decided to take the path of least resistance.
Let's talk about the verification of those text messages. Detective Markowitz found these as a motive. Avery Becker said she was going to break into Mackenzie Brackman's house. How do we verify this? Well, Detective Markowitz, in her investigation, found the call detail records for Avery Becker's phone. And by golly, wouldn't you have it, Avery Becker goes from her house to Mackenzie Brackman's house, just like she said she was going to do in the text. That's verification enough that she broke into his house. We saw that GPS record. Let's talk about whose phone was at 444 South Flower Street. It was Avery Becker's phone, not Blair Rowlands' phone. Avery Becker was at the scene of the crime at the time of the murder. The defense wants you to believe that Avery Becker had the unluckiest day of her life on March 6th, that someone stole her phone and just so happened to take it down to Coach Brackman's house and murder Coach Brackman with her phone and make up a case against her. Look, the evidence points to Avery Becker being at the scene of the crime at the time of the murder. You heard from two expert witnesses saying this. Avery Becker had a motive to kill Mr. Brackman. She was vengeful, she was hateful, she wanted revenge, and she got that on March 6th because she would get back at him if it was the last thing she did.
Thank you, counsel. That will conclude the trial in this matter. I know that our jury, our scoring panel, is filling out some documents right now. So before I hear that they have completed that, I'm going to be speaking to you just a little bit. And I don't know if Miss Rogers is on the phone right now. Miss Rogers?
Yes, Your Honor, I'm present.
Can you populate, or whatever term it is, the screen with the team members from both sides?
If everyone will just turn on your cameras, please.
Great. And Ms. Rogers, I'm just waiting for more people to populate. Whenever you're ready for the critiques, I'll fill in some time right now, but whenever we're ready to hear from the panelists, assuming they've turned their information into you, then we'll proceed. If you can just let me know that. I'm only seeing 3 folks right now. Let me see if I'm, oh no, we got more folks. Great. Great, thank you all. Now, let me just take it from the top here. First of all, thank you very much for taking the time to do this and all the hard work. We live in strange times. Obviously, we have to do this through a Zoom mechanism here right now. In the years past, when I've done this, you've been in a courtroom. There's been a court process involved, and it's all very unusual and very difficult. But I want to say and want to compliment you all on the hard work that you put into this. You were all very talented, both witnesses and lawyers. And I think you have a lot to feel good about from that perspective. I have conducted many a trial in my lifetime, and I would say that in these mock trials, the high school students that I've seen rank right up there with some of the best lawyers, and you are no exception to that. So you should feel very good about that. I'll tell you a little bit about myself, then I'll talk generally about the trial process, and then I'll answer any questions you might have while we're waiting for the panelists to complete their part of this. Ill or something along those lines. So I've done that for the last 2.5 years or so. I've done a little bit of this Zoom stuff. It's in the court process. It's called WebEx. That's our platform, if you would, that allows us to do this. And I've done the WebEx hearings with the lawyers and witnesses. So it's a little disjointed. It's a little difficult, and I have to apologize to you in advance. I probably cut out a bit because I have a difficulty sometimes with my internet connection out here. But that's my background. I'll just tell you, generally speaking, what I observed about the trial. As I said before, you were all very well prepared to proceed through this process. I'll just let you know a couple of things that came to my attention as I was listening to the evidence here. I think somebody mentioned during their opening statement about if there is, and maybe it was you, Ms. Latek, about having the slightest doubt. If you were to say that during the course of a trial, most of the prosecutors would jump up and say, it has to be a reasonable doubt. That's the standard of proof, the burden of proof that's here. Sometimes during witnesses, when they were testifying, witnesses were non-responsive of, did this happen? And you would get from the witness, well, no, but there's a good reason for that. And then there'd be a lengthy explanation for that. As a lawyer, you can indicate or you can object and say, Judge, this is non-responsive, and I would sustain that. If the question calls for a yes or no answer, then that's what the witness has to do, is answer yes or no. It's up to the other side to pick up on that and propound any further explanations if they want to. But if you're the examiner of the witness and the witness is not answering your question by running off, then you have a chance to say, Judge, this witness is being non-responsive, and I would respond to that if you had raised that objection. And I think I was trying to pull up while we were sitting here the charging document, and I didn't get a chance to do that. My recollection is there were the two charges there was second-degree burglary, but also the charge was felony murder. And I don't know if you had a chance to talk about that amongst yourselves, but that's a unique creature. And if you want to visit about that, I'm certainly willing to do that, because what that means, for example, if someone drove the suspect to that house, sat outside and waited, and they had discussed about what was going to go on inside the house, that is, a burglary were going to occur. If a murder were to occur inside the house, then the person who drove the car there and drove the suspect there could potentially be responsible. And there's been some discussion in criminal justice circles that the felony murder statute has been abused. So I don't know if anyone wants to weigh in on that, but clearly that would cover the person sitting outside in the car while so-and-so went in the house to commit the burglary. And if the murder occurs while the burglary is going on, I believe that that person in the car potentially could be held culpable. If you want to visit about that, I'm willing to entertain that. I'm pretty much done running my mouth right now. So if there's any questions that you want to ask me, I'm certainly more than willing to respond to that if I can. Any questions for me? I've lost everybody or not?
You did just freeze, Your Honor.
I just freeze. Am I unfrozen now?
Yes, you're moving a little shakily, but you're back.
I move shakily a lot. I'm old. So are there any questions that you want to ask me at this point in time? You certainly can do that. I'm willing to answer them if I can. So anybody have any questions?
Just when it comes to like objections and things, our responses, how could we get better in future trials for our responses?
When I try cases, if you're trying a case in front of me, I would always say short form objections. In other words, you say hearsay, lack of foundation, beyond the scope, cumulative, asked and answered. And then I should, if I'm paying attention, which I should be, I would know what you're talking about. If I don't, I would then ask you either at the bench to explain it to me or allow you to do that. But generally speaking, when I'm conducting a trial, I just want the short version of your objection. And many times I don't allow the other side to respond, because if I'm on track, I have an idea of what it is. If I do need a response, I would then probably have the lawyers approach the bench, because this is not a time or a place for you to present theories to the jury. I want to hear why this witness, why the question was objectionable or not objectionable. So typically speaking, when I'm trying a case, I want your objections to be very crisp. And by that, I mean, if the witness is not being responsive, first of all, that's an objection by the questioner. But if the witness has, if it's not relevant, if it's outside the scope, if it's hearsay, then you need to simply say hearsay. Now, sometimes hearsay can be complicated. And you talked about, I believe, Ms. Broccoli, hearsay within hearsay. So if you wanted to say something along those lines, that would point me more towards where you were coming from. But that's all that I would typically permit, because I don't want lawyers giving speeches in front of the jury throughout the trial. I want them to address the issue specifically having to do with what evidence is being presented. So that's what I would say in response to that, is that you want to be succinct but precise, in other words, with respect to your objection. And you can say, you can list them. You can say hearsay, irrelevant, lack of foundation, and then I'll have to consider all three of those if you think those three would fit. So that's what I would say to you at this point in time, if that's what you want to hear, if you're interested in that. Yeah. Anything else based on that, Ms. Brockler?
No, thank you, Your Honor.
All right. Does anybody else have anything that they want to mention to me or ask me right now? Not hearing anything. I must have been pretty boring then, huh? All right, because we're not supposed to tell you war stories. I got a million of them, but I'm not supposed to tell you war stories right now, so I won't. But I certainly have them, having sat on the bench and been in the courtroom as long as I have. If any of you are interested in becoming lawyers, it's a long road to hoe from the standpoint that you have to finish college and then go to law school. I know now that there's been some discussion from the standpoint that it's no longer 3 years. And I don't know if you lost me here.
We did for a second there.
Did for a second, all right. But law schools, legal education is changing. And it may become not quite so burdensome as it had been in the past. I'm sorry, it looks like I'm cutting out on y'all here.
No, we got you there.
All right. But if that's what you want to do, you have to, first of all, be in mind that it's a long road to hoe. And by that, I mean, you really have to be able to say to yourself, I want to put in the time and the energy and the effort to get this done. And then once you get it done, there's no guarantee that you're going to be standing in front of a courtroom your second day after graduating from law school and arguing your murder case. That's probably not going to happen. You have to kind of spend the time learning those skills, honing that. Part of this is a great way to do that because you get a chance to get a feel for what it is to become a lawyer. Because I'll tell you, what lawyers have to do frequently in the courtroom is think on their feet. And there are some people that don't like to do that, and there's nothing wrong with that. But you have to be able to do that in the courtroom, especially if a judge tells you, I don't care what you said here, I want you to answer my question about this. Then you have to be able to answer that question. I completed a hearing yesterday or a couple days ago on WebEx, and part of the problem was one of the lawyers, he wanted to tell me about A, B, and C, and I was interested in X, Y, and Z, and I had to bring him back and say, that's all good and well, counsel, but answer me about my concerns with pertaining to X, Y, and Z. But at that point in time, he has to think right then and right there, how am I going to answer this judge's question? Because even though I think something else is important, the judge is telling me he's interested in something completely different. And you have to be able to do that if you're going to practice law in a courtroom. Now, that doesn't mean you can't be a lawyer. There's plenty of lawyers who never step foot in a courtroom. But if you're going to practice trial practice, you have to be able to do that. And you also have to be able to accept losing. That's part of the process too. You learn more when you lose a case than you do when you win one. And that's hard to say, but it's like any other competition. You find out that the chances are you learning more, develop more greatly when you've lost. And if you haven't lost, you can't really grow. You know, I mean, life's not all peaches and cream. It's a tough go sometimes, and that's part of the process of growing up and also becoming a better lawyer. But that's part of the process, is that you have to go to school for 7 years after high school to even get licensed to practice law. And you got to get a job when you do that. And I would encourage you to keep that in mind, to think about it as you're progressing. Doesn't mean you all have to be lawyers. I have 2 sons and neither one of them are lawyers. They don't want to do it. That's up to them. That's their call. But if you're going to do it, you need to keep an open mind process. Any questions based on that? None? So what do you think you want to do when you get through with school? Anybody?
I know that. Oh,
no, go right ahead, Mr. Aragon.
I know that Ms. Brockler and I are interested in pursuing law in the future.
Well, that's good. Like I said, keep that in mind, but don't make it the, there may be something else that might come up in your life that you may say, this is really interesting. Maybe I had to do this, because being a lawyer is a tough thing sometimes. It can be really hard on you because there's not.
Too.
Pardon me?
It's very expensive too.
And it also, and you're right about that, going to law. I mean, right now, DU, I graduated from DU. I couldn't afford to go to DU right now. It's way too expensive. Now they have scholarships. There are ways to work around that a little bit, but when I went to DU, I paid for it myself. And that meant a lot of work involved. And I had a couple loans that I took out, but right now, I mean, it's probably close to 60, 70 grand a year. And that's not counting room and board. That's simply the educational part of it. That's a big chunk. I mean, I've had lawyers who appeared in front of me, young lawyers, good lawyers, who told me that they had, when they graduated from law school, debt in excess of $200,000. I couldn't do that. I could not step away and say, that's my nut. I gotta solve this, because there's not a guarantee you're gonna make that kind of money right away. practicing law. I know doctors go into debt to get through medical school, but there's pretty much a guarantee when they get out, they're going to make some big dollars. There's no guarantee you're going to do that as a lawyer. And that's a pretty heavy burden to put on yourself. So, and I think that's some of the process that law schools are rethinking, because I think right now law school attendance or admissions are down a little bit, because I think young people like you folks are saying to yourself, why am I going into this hole when there's no guarantee? And the profession is one that can be sometimes less satisfying. But I'm not trying to get you, I'm not trying to discourage you. I'm not. I just think you want to go into it with your eyes wide open. So, I mean, go to college, see what it's like, see if you can master some more skills, and then see what you can do with respect to the law school process. Anybody not interested in becoming a lawyer? This whole process has soured them on being lawyers.
Your Honor, I would, my aspirations are to become a criminal profiler.
Somebody with the FBI or something like that?
Yes, Your Honor.
You know, even the FBI, I don't know if you've looked into this, but they usually want people that have either law degrees or accounting degrees. So in addition to the 4 years of college, they want you to have some kind of a degree post-college, because the FBI doesn't kid around. You know, they're usually very professional in what they do. The other side of the coin is they may move you around a lot. If you're going to work for the FBI, your first job may be in Great Falls, Montana. And that's where you'll have to start your process. But they have a high expectations for their applicants. The other thing you need to be aware of is that most local law enforcement agencies don't think highly of the FBI, because when the FBI comes into town, they're the big shots and they have a tendency to throw their weight around. So they're not greeted warmly sometimes by local law enforcement. But if that's what you want to do, then certainly get your undergraduate degree, and then probably reach out to somebody like the FBI who does, I think, a little bit more of that profiling. That sounds fun right now, but when you get a little older, dealing with all the blood and guts may not be something you want to do for the rest of your life, because there's a lot of that with that profiling. Anybody else? Thank you, Ms. Lake.
Your Honor, I hate to interrupt, but I think our next trial starts at 12. So we might be pushing to get out of here with some comments.
And I'm waiting for Ms. Rogers.
Your Honor, we've received scores from the scoring panelists. So if the scoring panelists want to take about a minute each to give some feedback to the participants for their next round, that'd be helpful. Thanks.
Thank you. And I certainly wasn't trying to hog the floor. I just know that I've had to fill the void between when the trial ends and when the scoring panelists are done. So I'm done with that. So if the panelists have anything they want to say as far as critiquing, they can, but it needs to be short, because obviously they need to start on something here relatively quickly. So if either of my scoring panelists, Mr. Pereira.
Yes, Your Honor. So the first one's going to be an oxymoron a little bit, because I'm going to be speaking fast. But when you are presenting and things like that, for as much as possible, try to speak as slowly as possible. One thing is knowing the information. You guys are clearly prepared. You guys clearly know the information. So I know you guys know it, but be confident in that you know it, and try and avoid reading as much as possible. For the opening arguments or opening statements, rather, avoid being argumentative, but as well as good job addressing the burden of proof. I kind of agree with Judge as far as when you're defining reasonable doubt, use the term reasonable. But I like that you're trying to welcome the burden if you're the prosecution, and you don't, and you stress the difficulty of that burden when you're the defense. As far as responding to objections, definitely know the law, and try and be as concise as possible. So that's kind of my feedback. I think you guys all did very well. I don't have any particular negative feedback on any particular person or anything. So I think you all did well. So good luck going forward.
Thank you, Counsel. Ms. Patterson?
Yes, Your Honor. Everyone, I think you did very, very well. You should feel very proud of yourselves. I know being on Zoom and doing a hearing virtually is not ideal. I thought you guys did a great job on the share screening and being quick with getting exhibits up and then down and moving on. I would echo, as far as criticism, the speaking slowly, taking pauses, speaking clearly. I think you guys did a great job when you didn't know the material right off the bat that you asked for to be refreshed on your recollection. I thought that was very good. I thought you guys all did very well. So you should be really proud of yourself.
Thank you, Ms. Patterson. Ms. Newman?
So I agree. I think everybody did an excellent job. The only real criticism that I would have is to get more into your characters, especially if you're the witnesses. A couple of people looked like they were really reading their responses as opposed to answering their responses. But as everybody went along, I think you relaxed a little bit more and did a lot better as the trial progressed. Opening statements were a little on the shaky side, but closing statements were, I thought, very wonderfully done.
Thank you, counsel. I think that concludes it then, Ms. Rogers, unless you have something else.
Thank you, Your Honor. I think we're completed. We appreciate your service.
Thank you, and best of luck to all the participants in this process and in their further education. You all did a great job. We really appreciate your time. Thank you very much.
Thank you.
Thank